ಯಾವುದೇ Okay, sir. Thank you.
ಬಿ ಗ್ರೂಪ್ 31 ಮ್ಯಾಟ್ರ್ ಟೈಮ್ ಕೇಳ್ಬೋದಲ್ಲ? ಎಂಟ್ರಿ ಮಾಡೋದಿದೆ.
My lord, one submission, my lord. My lord, in WPFR number 5410 of 2025, the state consumer has impinged our order and dismissed our order filed under section 239 of CRPC and ordered us to pay a rupees of 40 lakhs plus interest of 12%, my lord. Tomorrow the case is listed before the trial court.
Memo for posting. ಮಾಡಿ ನಾಳೆ post ಮಾಡಿ.
There's a likely of issuing NBW, my lord. Kindly.
Let us see if it is issued, something we will consider according to law. Okay.
Oblige, my lord.
ಏನು?
This is second time.
Second time. ಯಾಕೆ ಹಂಗಾಗ್ತದೆ?
It's already covered by judgment, madam.
ನೋಡಿ.
It's already covered by judgment.
ನಾಳೆ ಕಟ್ಟಿ.
Particular sale.
ಒಂದು ಮೆಮೊ ಬಂತು ಅಂದಾಕ್ಷಣ ಪೋಸ್ಟ್ ಮಾಡಿಬಿಡ್ಬೇಕು. ಏನೋ ಅರ್ಜೆನ್ಸಿ ಇರ್ತದೆ ಅನ್ನೋದು ಕ್ಲಾರಿಸ್ ಮಾಡಿರ್ತಾರೆ. ಏನು ಹುಯಿಲ್ಗಳೇನು?
We serial number 29, Maharaj.
29.
I request for 2 weeks time, Maharaj.
29. All right. 2 weeks at the request of
Respondent.
respondent.
Much obliged.
Serial number 25, Your Lordship.
ನಿಮ್ಮ ಇವರಿಗೆ ತಿಳಿಸಿ ಇದೆ
Serial number 25.
ಪ್ಲೀಸ್ ಪ್ಲೀಸ್
Serial number 16, my lord.
16.
16, 2 days time may be granted, my lord. I have already informed the respondent counsel. 16.
116 go on. So if we have read it, we will not give. All right, 2 weeks.
That's all.
At the request of.
Serial number
My lord.
31, my lord. Serial number 31, man. 2 weeks time.
I am
31.
for the respondent in this case.
ಕೊಡ್ಬೋದಾ?
Kodi Swami. I also inform that.
1
Interim order.
2020.
Yes, my lord. 2 weeks, ma'am. Kindly after next week.
Yes, secretary is not in station, my lord. Kumbh Mela.
2 weeks.
Interim
At
order.
the request of both the sides, interim order to continue.
Serial number 26,
26.
I informed the petitioner counsel a week's time, my lord, week after next.
Week after next. At the request of.
Please.
22, 23, 24. Transfer pricing. Admit ಆಗಿದೆ ಈಗಾಗಲೇ. Post in final hearing. After disposal of the ongoing matter in WP in ITA number. ಕೊಡಿ. ಆ ನಂಬರ್ ಕೊಡ್ಬೇಕು.
Serial
Serial number 33.
33. ALGP.
There is some medical emergency in senior's family.
Okay.
Take for 2 weeks.
2 weeks. At the
Interim
request-
order maybe.
Interim order to continue
Much obliged.
for 2 weeks. Till next week. Okay. Yes.
Serial number 25, Your Lordship.
Third, HCGP takes notice for response number 1 as well. Okay.
Much obliged.
Serial number 25, Your Lordship.
25.
Yes, Your Lordship. 25. 2 weeks of time, Your Lordship.
Why it's a 2021 matter? 4 years are over.
Yes, Your Lordship, with some personal
Okay.
inconveniences
2
there.
weeks, finally. Yes.
Much obliged.
Serial number 1, my lords, I appear for respondent number 2, the auction purchaser, my lord.
For the.
My lords,
Yes.
my lords, it's a short point, my lords. It's just on the point that the auction purchaser, my lords, we have been issued sale certificate. And the petitioners have gotten a stay before the DRT after sale certificate is issued. The right of redemption, my lords, extinguishes on publication of auction notice, my lords. Therefore, if it can be had on Monday, my lords, we haven't received.
I'll explain, my lord, that.
Or time ಬೇಕಂತಲ್ಲ.
Time ಇಲ್ಲ.
You want time?
If we can, I don't have the objections of the bank. If I can just get those objections, my lord, and we can just get
lord,
some
this-
coitus to the matter.
You are not clear as to what you want to. You want to argue or you want time?
My lords, can it be had on Monday, my lords?
My lord,
Next week.
next month.
Next
ಅಲ್ಲ,
week.
ಆಯ್ತು.
Interim order.
Objection ಏನೇನೋ ಸರಿ ಮಾಡಿ.
ಅಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್ ನಾನು ಅಲ್ಲ ಸೆಕೆಂಡ್ ಕಾಪಿ ಕೊಡೋದು ಅದು ನಾನು ಕೊಟ್ಟಿದ್ದೇನೆ. ಐ ಆಲ್ರೆಡಿ ಫೈಲ್ಡ್ ಮೈ ಲಾರ್ಡ್.
The office objection is
We
compliant.
haven't received a copy.
You have not received copy?
No, my lord, this is 2022 matters.
Yes, sir.
And we argued.
Send one.
ಆಯ್ತು ಈಗಲೇ ಕೊಡ್ತೀನಿ.
For copy and coffee, never say we will not give.
ಅಲ್ಲಲ್ಲ ಇದು
But send.
ಆಯ್ತು ಐ ಗಿವ್ ಮೈ.
Interim order may kindly be extended.
Much.
Interim order.
Monday, my lord?
It will come someday.
It is posted for Monday, my lord.
Much.
Next week. Monday already you have posted.
Much.
Calendar is not free. Yes. Delete.
We have filed a affidavit file, madam. My lord, there is a delay of 250 days, my lord. Transfer pricing matter. Second.
Call out ಮಾಡಿ. Learned, ಯಾರು ಅಫಿಡವಿಟ್ ಯಾರ್ದು?
Please, my lord.
ಸರ್ವಿಸ್ ಅಫಿಡವಿಟ್ ಯಾರ್ದು? ನಿಮ್ದೆ. ನಿಮ್ ಸ್ವಂತ ಅಥವಾ ನಿಮ್ ಕ್ಲೈಂಟ್?
By the my lord,
Sworn to by whom?
office, my lord.
Continental, I think we have appeared in the tribunal. We will take instructions.
You will take that? Yes. ನಿಮ್ಮ ಯಾರ ಕಲೀಗ್ ಹೆಸರೇ?
Tanmay
Rajkumar.
Tanmay Raj.
ಮಹಿಮಾ ಗೌಡ್ ಅಲ್ಲ?
Miss Tanmay Rajkumar's name may be.
Tanmay Rajkumar accepts notice for respondent. Respondent. All right. I think instructions are very well. Suryanarayana, you want to file objections to the IA or?
We'll just take clients instruction. Let the
All.
file wakalat my lord,
All.
then my lords may consider.
Call after 2 weeks. Next. ಯಾರ್ದು affidavit? An income tax official
Please.
has sworn to an affidavit to the effect that respondent has been served with hand summons, which this court had permitted to take. First. Yes, sir. Name of the respondent is loudly called out by the court officer on the instruction of court. First off, there is no response. First off, there is no reason to doubt the version of affidavit. First off, next part. In view of the above, service on respondent SSC is held sufficient. Call after 2 weeks.
Is there delay, my lord?
220 days is there. Which book you will present to the library?
I'll give Ajay by Babu Krishnamurthy.
Ajaya by about Ajat Chandrasekhar.
I read it, my lord, 40 years ago.
The great, he has written 3 more books, Ajaya, then Adamya
Adamya.
about Vasudev Balwant Phadke, and one more, which I forgot this one. Okay, great work. Yes. Kanaba. Application allowed, subject to presenting Ajaya by Babu Krishnamurthy.
And transfer pricing matter, my lord, is my. Well, pure identical matters have been admitted.
ಅಲ್ಲ ಇಷ್ಟು ಬಡಿ ನೋಡೋಣ
ಅದ್
ಬಂದ್ಮೇಲೆ
ಕೊಡ್ತೀನಿ.
ಮತ್ತೆ ನೋಡೋಣ 2 books.
Can be admitted.
ಒಂದು all right, admitted on the substantial questions of law, following substantial questions of law.
Page
First off,
13.
Noted that some of these questions are being debated in an ongoing matter. Okay.
ಇಲ್ಲ. Surya, I noticed.
Yes. Yeah, allowed, standard format. Okay.
Your Lordship, appearing for the respondent in this matter, Your Lordship.
One sentence add ಮಾಡಿ. No objections are filed.
Your Lordship, last time we had prayed time for filing wakalat in this matter, Your Lordship. We had received the wakalat today, Your Lordship. We'll make sure that we'll file the wakalat in due course of the day.
ಆ ರೀತಿ ಟೈಮ್ ಕೊಡಕ ವಕಾಲತ್ ಒಂದ್ಸರಿ ಮ್ಯಾಟರ್ ಬಂದ್ರೆ 2,000 ರೂಪಾಯಿ ಹೋಗಿ.
Your Lordship, we'll find in due
2,000
course of the day, Your
rupees
Lordships.
ಆಗ್ತದೆ.
In the due course of the day, we'll file it, Your Lordship. We have received it.
ವಕಾಲತ್ ಹಾಕ್ತೀವಿ ಅಂತ ಹೇಳಿ one date and another date for filing of ವಕಾಲತ್.
No, Your Lordship, we'll be filed.
High court functions.
Your Lordship.
People will be laughing at us if you say that. ವಕಾಲತ್ ಹಾಕ್ಬೇಕು.
Yes, Your Lordship.
ಪಾಸು.
Oblige, Your Lordship.
Might be permitted to take notice on behalf of the respondent.
This will have to be dismissed, my lords.
Issue.
Dismiss, my lords. Monetary limits,
ಯಾವುದು CBDT
5, my lords.
ನೋಡಮ್ಮ.
5 and 9.
5 of
5 of 2024, my lords, also see 9 of 2024, my lords.
ನೋಡಮ್ಮ.
They both are
5 of 24 and 9 of
24, my lords.
24. ಗೊತ್ತಾಯ್ತಾ ಫಾರ್ಮ್ಯಾಟ್. ಎಸ್ ನೆಕ್ಸ್ಟ್. ಅಲ್ಲಿ ಅವ್ರ ಹೆಸರು ತೋರಿಸ್ಬೇಕು, ಅಪೋನೆಂಟ್ ಹೆಸರು ತೋರಿಸ್ಬೇಕು. ಹೆಸರು ತೋರಿಸ್ಬೇಕು.
My lords, they have been served, my lords. I have the affidavit of the assessee also, my lords, of the income of the department.
Ah.
The same, my lords, Tyco, my lords, which was also at item number 3, my lords.
ನೋಡಮ್ಮ 3 ದಲ್ಲಿ ಇದೆ ಆರ್ಡರ್.
Yes, my lords.
ಸೇಮ್ ಆರ್ಡರ್.
Issue of transfer pricing, my lords.
ಸೇಮ್ ಆರ್ಡರ್, ಐಡೆಂಟಿಕಲ್ ಆರ್ಡರ್. ಡೇಸ್ ಒಂದು ಬೇರೆ ಆಗ್ತದೆ. ಅವರ ಹೆಸರು ಒಂದ್ಸರಿ ಕೊಡಿ. Tyco ಯಾರು appear ಆಗ್ತಾರೆ ಅಂತಂದ್ರೆ ಯಾರು ಅವರಲ್ಲ. Same one. Next. ಎಷ್ಟು ಸರಿ 3 ಸರಿ ಬಂದಿದೆ.
My lords, both of them are not on panel, my lords, both Preetha and Manita, my lords.
They are not there.
Either Arvind Chavan, my lords, or Mr. Jeevan Babu, my lords. I take notice.
Arvind Chavan appears in the stead of Srimati so and Srimati so and so, who are said to be no longer on the panel. First, compliance within 2 weeks. Otherwise, next time heavy costs may be imposed. Okay.
24 days delay.
Madam, I allowed delay control.
Sir, transfer pricing matter, my lord, only two
Transfer
questions.
pricing, ಯಾವ question?
My lord, question number 1 and 2, my lord, page number 8.
ನೋಡಮ್ಮ 1 and 2. Okay. ಅಲ್ಲಿ question numbers 1 and 2 admitted on following questions of law. ಕೆಳಗಡೆ we have noted ongoing. Okay. Next.
It was delay of 36 days, my lords. 36 days, my lord, delay.
ಕಂಡು
It was also issue of transfer pricing, my lords.
ಸರ್ವಿಸ್ ಆಗಿ ಯಾರು ಬಂದಿಲ್ಲ ಇವರಿಗೆ ಅನ್ಮೈ admitted on the following questions of law. Noted. So.
10, my lords. 10.
64 days.
64 days. No issue of transfer pricing again, my lords.
ಇದರಲ್ಲಿ ಯಾರು ಎತ್ತಲ್ಲಿ ಯಾರು
10, my lords, issue 64 delays, my lords, issue of, they've been served, my lords.
ಕಂಡು
You'll take
questions ಯಾವುದು
1 to 4, my lords.
1 2
Again, issue of transfer pricing.
Oh, one, my lords. A and B does not arise.
A and B does not arise. Anyway, you can show it. The ಕೆಳಗಡೆ ಬನ್ನಿ. It is open to the respondent to show that these questions do not arise. Come on, when matter is taken up for final day. Okay. Yes. ಎಲ್ಲಿ ಪ್ರದೀಪ್ emergent notice. Sanmatina. Three, Sanmati panel council is requested, learned panel council is requested to accept notice for. Yes.
For the petitioner in this matter.
Yes, Ramesh,
Lord, the petitioner herein,
you are not coming to court, to our court or what?
well, I'm sorry, my lord, last little. Sorry. I was out of station on that. My lord, the petitioner herein is cultivating land to an extent of 1 acre 37 guntas belonging to him. Adjacent to that said land, a forest land is located. But the petitioner herein had encroached to an extent of 3 acres, 20 guntas prior to 1978. Since then, he is in possession of the property in question. Lord, I have produced the photograph, my lord, as per annexure A4 to substantiate my contention that, my lord, he has grown coconut and arecanut garden. There are more than 50 years standing trees are there. Lord, as per annexure, the Union of India, my lord, has called for the report from the respondent authorities to submit those who are encroached prior to 27/4/1978. While submitting the report, my lord, the respondent authorities have not included our land in that. But they have, as per annexure B, your lordship.
What for central government called for the report?
My lord, for regularization of the land, forest lands which were acquired, which were encroached prior to 27/4/1978. Your Lordship may kindly peruse annexure.
What is the significance of that date?
Please, my lord.
27/4/1978. Why, what is the significance of that date?
My lord, regarding that, your Lordship may kindly peruse annexure B, my lord. ಆ ಡೇಟ್ ಇಂದ ಮುಂಚೆ ಆಗಿರೋರ್ದ ಸಬ್ಮಿಟ್ ಮಾಡಿ ರಿಪೋರ್ಟ್ ಅಂತ ಕೇಳಿದ್ದಾರೆ. Annexure B is the report, my lord, submitted by the.
Forest land ಇದು.
Please, admittedly forest land, my lord.
ಮತ್ತೆ ಫಾರೆಸ್ಟ್ ಲ್ಯಾಂಡ್ ಇದ್ರೂ ಕವರ್ ಆಗತ್ತದೆ ಎನ್ಕ್ರೋಚ್ಡ್ ಲ್ಯಾಂಡ್.
ಅಲ್ಲ, prior to 1970, ಇದ್ರ ಪ್ರಕಾರ annexure B ಪ್ರಕಾರ prior to 1927.
ಬರಕ್ಕಿಂತ ಮೊದಲೇ ಆಗತ್ತೆ ಅಂತನಾ?
Please, my lord. ಅವಾಗಿನ ರೆಗ್ಯುಲರೈಸ್ ಮಾಡೋದಕ್ಕೆ ರಿಪೋರ್ಟ್ ಕಾಲ್ ಮಾಡ್ತಾರೆ. Then, my lord, this forest land survey, your Lordship may kindly peruse page number 20, my lord, page number 20. One minute, I will complete. Then, my lord, in view of this, I approached the respondent authorities. They have rejected my contentions. Then I filed a writ petition before this honorable court. My lord, the learned single judge of this honorable court, my lord.
Directed consideration.
So please, my lord. Now, proceedings is initiated, my lord, under the, before the special court against us for encroaching the forest land, my lord, without considering this aspect.
For YC.
2D
is also.
Please, my lordship, page number 82 of the order sheet of the special court, my lordship. It is alleged in the complaint that the respondent has encroached 1 acre of forest land in survey number 30 of Honnavali village and has cultivated illegally. Therefore, 2D of the definition is very clear, my lordship. Though it is prior to the act coming into the existence, who has cultivated illegally in the forest land, it amounts to the, they have encroached illegal, my lordship. 2D, the forest land which is included, my lordship.
No, two things. Whether 2011 Act empowers taking action against encroachers where encroachment took place before 2014.
But it is a forest land, my lordship.
It may be government land itself. Only to such lands it will apply.
No, even the agriculture, they cannot cultivate in the forest land. That's what 2D, its definition tells, my lordship.
Kodi, act kodi. Whether cultivation is an offense or encroachment is an offense. What is that offense?
Kindly, I'll read, my lordship. The definition of land is inclusive and not exhaustive. Land means.
That we have understood.
That's what, my lordship.
Yes, land is all right. Which offense is what?
That's what he has illegally encroached, my lordship. Encroached. Encroached also defined in the 54 of the, not this act, my lordship.
Forest Act. 64 of Forest Act.
1 second.
64 capital A.
54, please.
That is Forest Act. But question is not that. What Ramesh says.
Anyway, I'll secure instruction because since it is a forest land, I need to get instruction on this, my lordship.
Issue emergent notice. Learned AGA is requested to accept notice for
2 to 6.
Huh?
2 to 6, my lordship.
2 to 6. Learned DSG Shanti Bhushan is requested to accept notice for first respondent. Venkat Narayana. All Venkat Narayana. Alla 2 to 6 alla 2 to 7 ಆಗ್ತೀರಾ? ತಹಶೀಲ್ದಾರ್
7.
ಪಿ ತಾಲೂಕು 2 to 7. ಅಲ್ಲ ಅವ್ರ ಕಾಪಿ ಇಲ್ಲ ಅನ್ನೋದು 2 to 7.
Please,
7.
ಇಲ್ಲ, subsequently included. ಮಾಡಿ.
ಬರ್ಕೊಡಿ.
Please.
Points. The proceedings pending before the special court are stayed till next date of hearing.
Much.
First off, this interim protection is granted, taking the submission of learned counsel for the petitioner that in terms of a learned single judge's order in WP number.
In WP number 23879/2011.
23879 to 23887 of 2011 disposed of on 30/7/2019,
Please.
comma, an application seeking regularization of encroached land is pending consideration. Correct?
ಇಲ್ಲ ಇಲ್ಲ they have not considered
ಮಾಡಬೇಕು ಅನ್ಕೊಂಡು being considered, it's pending consideration or it is rejected.
it is rejected my lord.
That's also rejected.
Please my lord.
Then they should challenge that
That order you have to challenge.
endorsement.
Nodama, is granted on the taking submission of learned counsel appearing for the petitioner with prima facie value that the alleged encroachment is anterior to the coming into force of 2011 Act, full act perspective. Call after 2 weeks.
Because they have been served, my lords, issue of transfer pricing. They're not here, my lords.
Service agit.
Services, my lords.
Admitted. Which are the questions?
It was issue number 1 to 3 for 3, my lords. All on comparables, my lords, on transfer.
1, 2, 3.
1 to 3.
Noted. Next. Anisa Ahmed. So the short question is whether received or receivable under arrangement between your client and the subscriber, and not the taxes payable compulsorily on that. That's the question.
That's a short question, Manoj. And Manoj, this can be answered in two ways in my respectful submission. One is that when we reading the charging section, it has to be a strict interpretation. That is as per the Buthuram Agrawal and Govind Saran Gangasaran, both of them are saying same thing. And Manoj, though I could not find the Maxwell is out of print and not available in the
Maxwell and Tarshkut.
But the Maxwell also says the same thing when it says in a different way, and the same paragraph which has been used in Maxwell has been used in Buthuram Agrawal. Buthuram Agrawal is the Constitution bench judgment. So it says that what is not written in the clear words can't be read into it. There is no analogy, no equity, nothing is applicable. Absolute strict interpretation has to be undertaken. Now, Maxwell says in a different way, saying that wherever there is a burden of financial nature, or there is a restriction of the fundamental rights or the rights of the citizens, in those circumstances, strict interpretation is the only thumb rule. That is what Maxwell says in sum and substance. Same line, paragraphs and everything same.
That is
used by
that
Honorable Supreme
expressio unius exclusio ulterius. That is the maxim.
That is another one which what is falling from my lords is this, that a special one will actually supersede the general one. That is what 4G will.
That is not. That is specially by
special legislation will prevail over the general legislation. So this is not the what is coming out of this Maxwell and these two judgments. That is known that there were other judgments also. I will place before my lords for the assistance. Now, given that,
let us read section 3. Na, you read which is that section 4G and
3.
Let us read 3. Let us see it again. We raised this question because Aditya raised that question. Because one is absent and one is conspicuously present that way.
Sorry.
Please go ahead.
Yes.
I'll make submissions.
But may I just read that 4G?
Yes.
Notwithstanding anything contained in section 4 capital C, 4 capital D, there shall be levied and collected a tax at the rate of 6% on the amount received. I will skip this line, Millers. I'll go to the last line, which is relevant to me. And by a direct-to-home service provider towards providing television signals under the direct-to-home scheme, Millers.
You fit into last one.
Yeah, because I'm a DTH operator, my lord. I'm licensed with the Ministry and Government of India. my lord. So in my respectful submission, what I'm trying to propound, my lord, is this, that the levy and collection at 6% on the amount received towards providing the
Signals.
service and signals. Signals is actually service. That's all. So that is what it says. So what amount I received, I received 100 rupees, and 100 rupees has to suffer entertainment tax and has to suffer service tax. That's all. But I'm not even going to the character of it, because if I dig further deeper in character of it, that character itself is faulty. Character itself faulty, because when this similar question came before the Honorable Supreme Court in bed and breakfast case, now they said that there has to be rules for determination, because aspect theory is applicable. Now, aspect theory is applicable, then rules of determination has to be there. There could be two or different aspects. I'm not on that, Malas.
No, to that level, we need not, we need not go to at all.
Yes, Malas. So, Malas, then how to address in my respectful submission is this, whether it is saying that the service tax component has to be
Included in that received or receivable.
So, Malas, if it is not there in the clear words, then it is not to be read into it, Malas. So, Malas, I will just like to
Any rulings, sir? Just rulings? So I understood the
yes,
point.
Malas. I'll just place, Malas, that Muthuram Agarwal, Malas.
What you say is in substance. What you say is the expression received or receivable is like consideration
That's all.
for the services you render
Yes, Malas.
or the goods you give, whichever way.
Yes, Malas.
And it cannot be added with what is compulsorily payable under law.
Yes, Malas. So,
So what you receive,
yeah.
what you receive as consideration is the focal point of section
4G.
4G.
Yes.
4G, Allah?
4 capital G.
4G, you're right. 4G.
Malas,
That is your contention.
yes, Malas.
So tax component cannot be included.
Yes, Malas.
GST cannot be included.
Yes, Malas.
Only GST?
No, but GST, it is prior to GST period. It is 2006 and 9 period, Malas. And the controversy is further pending.
How courts have answered this
Malas,
question arose before any high courts in the country?
Malas, in fact, the issue how to read the charging section has arisen in various high courts, and where the department tried to draw the analogy or presume something or to draw the inference out of it. So the Honorable Court said, which is confirmed by the Supreme Court also, that the analogy inference is not permissible. What is written in the clear words has to
That
be.
should be the basis.
Yes. And any malignancy in the charging section will actually completely destroy the charging section, and the citizen is free.
Okay.
Malas, I would just like to read para 12 and 13, which
Anyway,
is.
you're not challenging the section.
I'm not.
You are only on interpretation.
Yeah, that's all, Malas. That's all, Malas.
Which
Para 12 minutes.
Just for completeness, my lord, section was challenged,
Upheld.
struck down by the single judge, upheld by the Supreme Court. Consequent to Supreme Court upholding it, division bench may not allowed my writ appeal.
Malas,
Whether in upholding, was there any occasion for interpreting the provisions?
no,
There
Malas.
there was not.
There was no such thing. It was a constitutional virus.
Malas,
In fact, it was said that the two spheres are independent. The flow of content is the service, and the provision of entertainment is exigible to entertainment tax. The service element is taxable by the union. Entertainment is taxable by the state. There is absolutely no, and it went to the extent of saying merely because the union has enacted the Cable Television Regulation Act,
That
does not take away the
power of
taxing.
the state. But to remind you, K. Abbas, the great director, author also, he wrote book on Indira Gandhi, that woman. He said, why governments are nowadays levying entertainment tax on cinemas when there is absolutely no entertainment at all?
yes, sir. Malas, just to complete his version is that the entire matter went up to Supreme Court. Supreme Court has heard the arguments and it is pending for pronouncement minutes. heard by the Honorable Justice Nagaratna, my lords. So, why I'm so, because I was part of that batch, my lords.
Again, it is still pending.
It is, arguments have been advanced and concluded.
Yes, it is already upheld. There is a
No, no.
reported judgment I saw.
My lords, it is the entire matter has gone to Supreme Court.
Okay.
So,
Which state? Our state.
I'm not aware of
Our
this state.
state is already upheld.
Well, our state is upheld, my lord. Justice Sodi's division bench has.
Reversed single judge's order.
Size given.
Matter went to apex court and apex court upheld the legislative competence of the state. There is a judgment of
I'm
that
not aware.
last year. Anyway,
Please forgive me my.
we need not go to that because you are not.
My
telling.
ignorance, my lords, my ignorance, my lords.
No, just I wanted to know, while upholding validity, generally courts will discuss the scope, content, policy content, intent, these things generally they will go through. That's the reason I asked. Anyway, you mean to say that received or receivable must include the tax component also?
Whatever there is, my lord.
How? Will it not be a tax on the tax?
There is no prohibition on tax into tax, my lord. First of all, my lords, this is a 1958 statute. The question of value added tax at that point in time did not exist. Nonetheless,
Tax is.
my lord, even today, my lord, I pay cess to the income tax department, which is nothing but a tax on tax. When I pay.
Not enacted is his question. Constitutionally speaking,
My lords,
there may not be prohibition as such. If a legislature wants to levy tax even on death, it can.
It can.
To borrow the words of A.V. Dicey. But question is whether the legislature has done it is the question.
my lords, my respectful submission is that the legislature has said all amounts received are taxable
Received
at 6%.
or receivable.
Received or receivable.
But that,
Which-
that has to be in the nature of consideration for the services they give, the entertainment, consideration for entertainment. It appears that way.
Maybe so, my lord. I mean, I'm in the hands of this honorable court, my lord. Maybe so.
No, just it's a discussion.
Maybe so. That may be, my respectful submission is received or receivable. Receivable is because the incidence is at the time of invoicing. I raise an invoice today. It may be receivable in terms of credit 15 days, 30 days, etc. But since I have invoiced it, it becomes
Whether you
taxable.
actually receive it or not,
Correct.
if it is shown to be receivable,
Yes,
he has to pay tax.
please, my lord.
The subscriber may not give his money for 1 year. That is no ground for deferring the payment to
Please.
Caesar.
Now,
Has to make payment.
a further breakup in the amount received or receivable is not contemplated by 4G. Now, in that, for example, it could have said tax on profit. So all expenses, taxes, etc. are deducted. It could have said excluding tax in the manner that 3 says. It could have, those elements are missing, my lords. And my respectful submission will be that, my lords, taxes are the one aspect is when an individual comes and says, look, I am aggrieved because there is tax on tax is one aspect. But when I, as revenue, stand over here, I am standing as this trustee of the public and the state at large. My interest is larger. Therefore, my lords, in order to prejudice the public and the state at large, there has to be some compelling reason why an individual's interest has to be upheld.
No, we are not upholding interest. We want to know whether you ever intended to levy.
That is my
We
intent.
are not on that.
Why?
We are just construing the provision.
Yes, my lord.
Maybe, I repeat,
My lords.
on death you can levy tax.
Yes, my lord.
But question is, have you levied?
I have levied on all receivables. I have levied on all receivables. Received or receivable, I have levied. Now, carving up of that, whether this honorable court wishes to carve up a receivable and say that, look, that which is being paid to the union government has to be excluded from the meaning of receivable, is, my lords, we are in the hands of this honorable court. My submission will remain that there is no occasion for such carving up.
Any decision all these years, this act is there since half a century.
But in my,
We were reading particular paragraph of.
This
Buffett's petition.
particular amendment, my lord, came in 1995.
which one?
I think by then you were not even advocate.
I was not.
Well, that has
But I
come,
was. I was.
That has come on 2006, my lords.
Huh?
2006, the charging section was inserted in 2006, 1st April 2006, my lords.
2006.
And the expression receivable was inserted in 2000.
No definition in the act. Let us go to the dictionary clause of the act. What do you act?
I stand corrected.
Yes,
My
here.
learned friend is right. It is 2006.
Very good.
I think 4C was inserted in.
But
But for G also,
Yes.
2006 only.
4C was inserted in 93. 4G, my learned friend is absolutely right. It is in 2006.
The act doesn't define the expression tax. Act doesn't define that. And neither the rules define that.
Definition.
Numbers. So, but can I, there's a.
Any other statute uses the word received or receivable? Any other statute like service tax act or some other tax relating to taxation?
Service tax, my lord, has been upheld, has been held to be a value-added tax.
Just to.
My respectful submission is that there is no ground to treat this as a value-added tax.
May I just read that paragraph 12?
Paragraph 12, no?
12. It is the loose one.
It was under which act?
There's a general principle I'm reading, it is otherwise relating to the MP Municipalities Act 1961.
Municipal taxes.
Yes, but the principle which is there. Paragraph 12 and 13, these are two paragraphs which I want to read, Maharaj. And the relevant part is starting from 5th line, in our considered view. In our considered view, Maharaj, 5th line, Maharaj. In our considered view, this position cannot be accepted. The intention of legislature in taxing statute is to be gathered from the language of the provisions, particularly where the language is plain and unambiguous. In a taxing act, it is not possible to assume any intention or governing purpose of the statute more than what is stated in the plain language. It is not the economic result sought to be obtained by making the provision which is relevant in interpreting the fiscal statute. Equally impermissible is the interpretation which does not follow from the plain, unambiguous language of the statute. Words cannot be added or substituted so as to give a meaning to the statute which will serve the spirit and intention of the legislature. The statute would clearly and unambiguously convey the three concepts of tax law, that is the subject of the tax and person who is liable to pay the tax and the rate at which the tax is to be paid. If there is an ambiguity regarding any of these ingredients in the taxing statute, then there is no tax in law. Then it is for the legislature to do the needful in the matter. Whereas the paragraph 13, in the case of the Bank of Chettinad Limited versus CIT, and the Privy Council quoted with approval the following passage from the opinion of Lord Russell of Gillion in IRC versus Duke of Westminster. I confess that I view with disfavor the doctrine that in taxation cases, the subject is to be taxed if in accordance with the court's view.
No inference and analogy.
Yeah.
No taxation by inference and analogy is the principle.
Correct. So that is para 13, Maharaj. I confess that I view with disfavor the doctrine that in taxation cases, the subject is to be taxed if it in accordance with the court's view of what it considers the substance of the transaction. The courts think that the case falls within the contemplation or spirit of the statute. The subject is not taxable by inference or by analogy, but only by plain words of the statute applicable to the facts and circumstances of his case. Lord Cranes said many years ago in Parrington versus Attorney General at such and such page, as I understand the principle of all fiscal legislation, it is this: if the person sought to be taxed comes within the letter of the law, he must be taxed, however great hardship he may appear to be judicial mind to be. On the other hand, if the crown seeking to recover the tax cannot bring the subject within the letter of the law, the subject is free, however apparently within the spirit of the law, the case might otherwise appear to be. Whereas this is the Constitution bench judgment.
Principles as to how it should be.
It
is more on principles of construing a taxing law.
Yes, so that is one. There is another.
You are coming from Delhi.
Yes.
Delhi. Whether in Delhi there is similar perimaterial legislation, Entertainment Tax Act.
Yes, Maharaj.
How Delhi High Court has interpreted your provision?
But it's on a different way. It is worded, and it is on the per set-top box basis. So that was under challenge, and the challenge was declined, and the matter went up to Supreme Court, and it's a part of the badge which is under consideration before the Supreme Court. But the another judgment which is Govind Saran, Ganga Saran, very
On what proposition?
It's para 6 only, just.
What is the proposition? For what proposition you want to cite the decision?
Yes, Malas.
Suppose if we agree,
Yes.
still you want to cite the decision?
Uncertainty or vagueness will fail the levy. That is what it says, Malas, in sum and substance. Last line, para 6, Malas.
That will inure to the benefit of the assessee.
Yes, Malas. So I will not bother Malas with this further, Malas. So, Malas, in my respectful submission, that the 4G, it doesn't say so. What my learned friend also quoted.
While amending this act in 2095 or no, 2006, whichever way, was there any report of any expert committee as to why this is done?
I can check that, my lord. Offhand, I do not have it.
Malas, may I just to say to assess Malas and just to complete the information. What has happened the first time that there was a case in Honorable High Court of Patna, and where this similar situation arose in the Sky cable matter, where the charging section was not clearly defining the taxable event. So it was unamended, like in 1958, where the amendment has come. Had it been the previous form, the levy would have been completely declined and would have been set aside. In those cases, the Honorable Supreme Court High Court has decided that no, this charging section is ambiguous, taxable event is not defined, therefore levy is not sustainable, and therefore, and subsequently that judgment was upheld by the Honorable Supreme Court. Similar situation arose in the case of Honorable High Court of Uttarakhand, when Honorable High.
They are not directly on the point at all. What all you are mentioning?
Yes, Manas, that's what I'm saying. That's what I'm saying. But it's only on the point that the charging section has to be very, very specific. Any ambiguity or malignancy will go to the go in favor of the SSE and against the department Manas. So what I'm trying to say here, my submission is that it doesn't say so. What my learned friend also quoted, that the cess. So Manas, when we look at the cess was introduced. Let's look at the situation as a matter of illustration to be considered Manas. That in 2007 and 2004, the cess was introduced on the service tax. So the charging section of the cess act, Finance Act says so, that there shall be levied a cess at the rate of such and such on the service tax component.
So section itself says that.
Itself says so. And that too, Manas, that is also under the particular entries of list 1. And in addition to that, they have entry number 97 also, Manas.
So residuary.
Now, this similar 97 is not available to the state.
Only center.
Yes. So, Manas, that is my submission. Now, if I say, Manas, that it is applicable, then it will be beyond the competence of the state legislature to levy the entertainment tax on the service tax component. In case they exceed their jurisdiction, this is my submission, Manas. Now, this similar situation, Manas, not like this, but the simple interpretation has been given by the Honorable Supreme Court in Anand Swarup, Manas. I just want to cite that, Manas.
Brother Aditya, suppose, one second.
Sorry.
Suppose service tax, you say there can be tax on tax.
That can be
But that is conditioned by one principle. Both the taxes should be leviable by the same legislature. Suppose state cannot impose a tax on the income tax. It appears that way. If you say that what he is saying is, the cess is the levy by the center. Similarly, service tax is a central levy. Okay. If you are, you want to levy tax, entertainment tax on service tax also, where is the legislative competence?
The incidence of tax is on provision of entertainment.
Correct.
There is no separate incidence on tax on the act of payment of service tax. What the tax is leviable on the collection from of,
On the collection accruing because of entertainment.
correct. Now, from that,
But this is not because of entertainment. It is incidental to. It is not because of entertainment.
my lords. In which case, my lords, your lordships may
In fact, sir, there is one famous judgment of Privy Council where the question arose. That was under which section? I don't remember. There is such a judgment. It all depends upon the thickness of the nexus between accrual.
my lords.
And that is followed by the apex court. Which decision under the Income Tax Act, which you argued other day about when I was sitting on Chaitanya argued that point and you were the opponent in that. The Privy Council, the famous judgment, Lord Atkin's judgment of the House of Lords, not Privy Council. Lord Atkin said it was somewhere it is belonging to or akin to, accruing from. That way the section was reading and that was being interpreted. Anyway,
Your lordships,
what you say is, what his version, please understand. You say the legislature can tax the tax.
the legislature.
Yes, cess is tax on tax.
Yes, yes.
That principle applies provided the legislature has competence to tax X and tax Y. That is, if you want to both, in respect of both, you should have competence. If you are going to tax on the central tax, where is the competence?
My lords, I'm not able to show competence. I'm not able to show competence. Your lordships may kindly take, my lords, the revision petition.
Well, before that, he starts, and I just can read that Anand Swarup, that's the, because that clearly decides the controversy.
Ananda?
Anand Swarup, which is page number 111, my paper book, which I have given yesterday.
This question is not directly treated by any court.
Well, that is what I'm saying, that they have decided about the Sales Tax Act, how to read that, and whether the statutory dues can be read into the part of the consideration or not. That is what it says.
Where is that?
Yes, it's starting from page 111, the Anand Swarup and Anand Swarup Mahesh Kumar, Commissioner of Sales Tax. It's Honorable Supreme Court judgment. I first like to take to para 10, where the questions are formulated. Then I would like to go back the controversy. May I just read that para 10? These are the questions which the Honorable Supreme Court formulated, which is page 115.
You're right. Three contentions.
So I'm concerned here with the contention number 2, which is my contention here.
The market fee payable.
That the market fee payable by under the Adhiniyam being a sum which can be collected from the purchaser by virtue of the provision contained in section 17 Roman 3b of the Adhiniyam by the commission agent who is required to pay the same to the market committee cannot be considered as forming the part of the consideration paid or payable by the purchaser to the commission in respect of the purchase of the goods as an auction held within the market area established under the Adhiniyam, and therefore it cannot be included in the turnover of the purchaser for the purpose of levy and tax under section 3D of the Sales Tax Act. That is a question, same question is mine. Adhiniyam is the Mandi Samiti Adhiniyam, where the situation is that the agents are operating and agents are recovering the market fee from the purchasers, and that is deposited with the market committee. And I'm not concerned with the third question. So question number 2 is only one.
Therefore, it cannot be included in the turnover purchases for purposes of levy of tax.
Levy of sales tax.
That's
right. May I just go back to the the first paragraph so that the controversy would be clear. Now, this question has been upheld in the favor of the assessee.
Understood. Go to next point.
Next point. May I just only read that? There's one more paragraph which is important. where it says that what is the requirement. They have drawn the two kind of legislation, my lords, where the money has to be recovered, the tax amount has to be recovered from the subscriber, my lords, or the consumers or the customers, and the statute where it is not to be recovered. So that is in para number 13, my lords. If my lords permit me, then only I read, my lords.
13 of
The same judgment, my lords.
Datta.
Yes, my lords. Anand Swarup, my lords.
The argument has been.
My argument is on behalf of the appellant is that when a dealer who in this case happens to be the commission agent is permitted by law to collect the market fee which he is liable to pay to the market committee from the purchaser, such market fee cannot form part of the consideration for sale and therefore cannot be included in the turnover of the purchasers for the purpose of levy of tax under the act. But on behalf of the state government, it is urged that all the sums paid by the purchaser to a seller or to a commission agent for the purchase of the goods, including any tax or fee payable by him form the consideration for the purchase and therefore are liable to be included in the turnover of the purchaser. That is the contention of the department, my lords. Reliance is placed by the state government on George Oaks versus State of Madras, in which this court, while interpreting a similar provision in the Madras General Sales Tax Act, observed that the expression turnover meant the aggregate amount for which the goods were bought and sold, whether for cash or deferred payment or other valuable consideration, and when the sale attracted purchase tax and the tax was passed on to the consumer, what the buyer had to pay for the goods, including the tax as well as the aggregate amount so paid, would fall within the definition of turnover. In the above case, the court was construing the meaning of expression turnover appearing in a statute in which there was no provision authorizing the seller to recover the sales tax payable by him from the purchaser, although the price of the goods realized by him included the sales tax payable by him, and thus he had passed on his liability to the purchaser. The next decision on which the reliance was placed by the state government, that is all by state government, Delhi Cloth Mills versus Commissioner of Sales Tax, Indore. In that case, this court held that the expression sale price as defined in such and such provisions included the sales tax collected by the dealer from his purchase as well. There was no provision in the statute imposing any liability on the purchaser to pay the tax imposed on the dealer, and there was no law empowering the dealer to collect the tax from his buyer. In both the decision referred above, this court relied upon such case in which it had laid down that the price payable by the purchaser under the contract of the goods for the purpose of certain penal provision was the price fixed by the contractor, and the seller who wished to recover the amount of the purchase tax should accept where an adjustment was authorized by the statute, including the amount in the sale price fixed from them, so fixed. From the above observation made in the decision referred to above, it follows that where the dealer is authorized by law to pass on the tax payable by him on the transaction of sale to the purchaser, such tax does not form the part of the consideration.
Understood.
Now let's look at Service Tax Act. Service Tax Act has the application of Section 12B of the Central Excise Act by force of Section 83 of the Finance Act 1994. It's a reference. Incorporation by reference of Section 83. 12B says the money has to be recovered from the purchaser. And therefore I pass on because therefore I pass on the entire incidence to the.
Here passing on is not there. In your case.
Passing on.
In your case also there is a passing on.
Yes, Malas.
Yes.
It is paid by the subscriber.
Correct.
Malas, I just want to read that judgment of All India Federation where they have said actually the tax is on whom? Tax is actually on the commercial activity to be borne by the consumer. It's a destination-based consumption tax. That is what it says. So the relevant paragraphs, sir, Malas, sir, 6, 8, 9, 20, 24, and 25. It is the Honorable Supreme Court judgment.
I'm not contesting that.
Those propositions you don't contest. We do not contest.
So Malas, now the second point, Malas, is this, that the Anand Swarup Mahesh Kumar is 1980 judgment. And this is followed in the subsequent judgment, which is the part of the paper book, State of Punjab versus Gurunditta Mal Shruti Prakash, and then up to 2004, then 2005. And in fact, the Hyderabad Race Club versus CTO is also on the same thing. There was an issue whether the betting tax and entertainment tax has to suffer another tax. They said no, because you are only operating as an agent for the state exchequer or the union exchequer in my case. So you collect and deposit, Malas. Now, Malas, now I want to show, Malas, that I have placed on record that the bills. The second point is that what are the documents that how do I bill to the consumers, my lords? My lords, there is a page number 794 of the memo of my revision, my lords. Which is a CA certificate. And the CA certificate only says, refers to, which I have given the sample e-bills, which are sent to the consumers. Manas, they are starting at page number 746, Manas. So Manas, kindly see that the name Mr. Chanappa SH. And with regard to this, there is a certificate which I have also placed on record. Now it shows that, Manas have this page number 746.
Yes.
So Manas, kindly look at the entries here. On 28/4/2006, there was a Dish Next CHCP offer Canada 2006 subscription charges, which is going to 861 or something like that. Manas. So it's very small font. Then there is a service tax component. This is a statement because a running account. The moment he make the payment, it is sent. And then he makes another payment, again it is sent. So the last one will keep showing the previous history also of the payments and the itemized bill. So what the consumer knows what he has paid towards the consideration, what he has paid towards the service tax. Now, therefore, that kindly see that 2006, then in 2007, subsequent entry, when he makes the payment, and which is on April 2007, then there is October 2000.
Same
pattern. So, it is, I have several of those I have placed on record. It is running up to page number 815. I only illustrated because there could be at least 1 million of subscribers in the state of Karnataka. So it is not possible to place all of them before my lords. So now the second question which the Honorable Tribunal has answered negatively against me is that there is no document I have shown.
When
that,
you have produced the.
That's an itemized bill has been undertaken by me, which I have placed. Now he says, what is invoice? Well, it is not invoice. So there is no requirement of invoice. It is this invoice. So I have placed on record the dictionary meaning of what is invoice, because it's not a term of art, which is defined somewhere in statute and it will have the fixed connotation everywhere. It is not so. It is not like sales, which is defined in Constitution in 366/29A, and the day Malas have pronounced the judgment. So, Malas, the invoice, what it says, what is the meaning of invoice? Malas, kindly at page 919, Malas, the Black's Law Dictionary, Malas. 919, Malas. Page number 919, Malas.
Bill memo.
Yes, Malas. And yes, Malas. It's a Black's Law Dictionary, Malas, and as Malas, subsequent page, Malas, 920, and first, second, third, fourth. On the right-hand side column, Malas, the fourth item, Malas.
Invoice.
Invoice.
Return account.
So, Malas, I may just read that. It's very important for me.
Yes.
A written account or itemized statement of merchandise shipped or sent to a purchaser. Itemized statement. Consignee, factor, etc., with the quantity, value, or price and the charges annexed, and may be as appropriate to the consignment or a memorandum shipment as it is to a sale. Joseph B. Copper and such document, I'm just skipping that citation, document showing details of a sale or purchase transaction. So it's my sale transaction of services, Millers. A list sent to the purchaser, factor, consignee, etc., containing the items together with the prices and charges of merchandise sent or to be sent to him, a writing made on behalf of an importer, and so on and so forth, Millers. So, Millers, what I'm trying to say is that.
Okay.
So the Learned Tribunal says that what I have placed on record is actually does not qualify to be the invoice.
What Webster says?
He says it is not the invoices. I have shown the running account statement which is sent to the customer, which is page number, I have shown that on page 746, just kindly take note of page 746, and the invoice.
Webster is page number?
Webster's is page number 268, 921, 921, 922 is the, is the third item in the middle column, It is a little dim, but I can read,
It's 796, by the way.
922.
922. 922.
No, the so-called invoice, the running account is 796.
796, sir.
Because
Yes, yes.
the 778 is our court's order.
Correct.
Yes,
796.
796, or 746.
But that
Sorry.
number was wrong.
I'm so sorry,
No, it's all right, but we
So,
saw the
Balas-
correct number.
But is that a list sent to the purchaser containing the item and charges of merchandise? That is the definition by Webster's. And this is Webster's Comprehensive Dictionary, International Edition. And the on subsequent page, New Lexicon, it also repeats the same definition, Now, therefore, the finding returned by the learned tribunal is not correct. I can show the finding,
We have read the papers.
So,
Heard result.
so deeply.
Judgment tomorrow.
The last thing which Malus have said, what is, if the text is defined somewhere, GP saying statutory interpretation, it says to some extent that what is the meaning of tax, So I can,
Tax, any number. Tax, fee, levy.
yes,
license
that's
fee.
fine. So I don't have to bother.
Plethora of
So,
judgments, that which is 1983 Supreme Court Justice Chinnapareddy's judgment, where they
Yes,
considered which is that 1980 famous judgment, the 5 judgment decision, Sanjeev Coke versus so and so. They discussed what is tax, what is a fee, what is the difference between these two, what is meant by levy. So many things are there.
So,
May not. Thank you,
Mr.
Mr. Tareen.
So deeply realized. But my final submission is that the Anand Swarup covers my case, and my petition can be allowed.
Consider. You want to say anything more? That's all.
So great.
Very.
Regarding
One, Mr. Sarin, 1 second. Mr. Aditya, one small question to you. Agricultural income tax is in the state list.
Yes, ma'am.
All right. Can the center levy tax on agricultural income tax? Because your proposition is tax on tax is constitutionally not impermissible. There can be tax on tax. But just I want to ascertain that tax on tax is constitutionally permissible, even in terms of entries in the 7th schedule, read with 246 to 254. Only if in respect of both taxes, they have legislative competence. It appears that way. I have not read any write-up on this. If you have any.
I have brought this also. I was anticipating this question, So, these are the 2 documents, These are the circular issued by the central government. Those are central government has the residuary power, and but they have clarified their position in the service tax itself.
No, circulars may not be, they need not constitute legal opinions. And it's a state subject now. What center will say, we are not bothered, they may say. We are a federal structure.
So only one sentence I would use from here.
I wanted to know from any decision or from write-up by some scholars like Paili, Sirvai, of that state.
So, if I may say this, if I may permit it to be, that unless there is a charge, this subject which is defined under 7th schedule says that the topics of legislation are sources of revenue. So entertainment is a source for revenue for them, services is a source for revenue for them, but the incidence of service tax itself is a source of revenue and defined as topic in one of the three lists or only two lists, then only either of them can levy the tax, my lords. Otherwise not, because the constitutional discipline 246 1, my lords, completely bars. And they say it is not permissible, and Sherwai gone to the extent of saying it's a constitutional fraud, my lords. It's a fraud on constitution express, this exact term used.
This question Shirwai has not treated.
So, my lords, I will say ki excessive, in excess of jurisdiction.
That is what he calls it, all right. But Shirwai's fourth edition, I have read all the 3 volumes. This is not treated. Anyway.
Malas, can I just read only one sentence? Because Malas just can see that. There's a
No, proposition is tax and tax is permissible, provided that in respect of both, there is legislative competence.
Please, ma'am.
This proposition I needed. This proposition as such is not treated by Shirwai to my vague memory. I may be wrong also. You, if possible, send it.
Well,
And
I will.
you also just.
I'll do that.
Very.
Just only one indulgence I want. What I'm saying is that the 2 circulars, though I know Malas it's not.
No, we'll not look into that because ours is a federal structure. By your interpretation, you can't curtail our power, that may be the answer. Therefore, number 1. Number 2, which are these circulars?
Well, it's only one.
Circulars are not legislative instruments except when
Absolutely,
they are authorized and in respect of that act.
Yes, ma'am, that's all. Yes. Good.
I'm obliged.
I will try to find out that.
Just
document
find out.
And place it before
Yes.
my colleague will submit.
Very well. Okay, thank you.
Deeply obliged.
But if my lordship permits me, my lord, so far as agricultural income is concerned, it was included in the total income for the rate purpose.
Correct. Not for taxation. It only changed the slab.
Slab.
That's
And again, it's.
That is upheld by the apex court also. That's okay.
I pray for 2 weeks' time.
That
I have
will
to
be
secure
taken up
agreement copies.
Next week, my last covered issue.
Covered
2
issue.
2 weeks, I have to get secured the agreement.
2 weeks. Yes.
My lord, the respondent, my lord, here was a registered trust.
Yes.
A search came to be carried on, my lord, under one section 132 of the Act. Some incriminating documents were found, and it was found, my lord, the funds of the trust were utilized by the trustees for their personal use. And subsequently, my lord, under section 12AB2, that registration came to be cancelled.
There is power to cancel the
Cancel
registration.
it because it's very specific. What it says.
But it is with the prospective effect or retrospective?
I'll come to that, my lord.
Yes.
It was brought in, my lord, in 2022 with effect from 1/4/22. Here the assessment here, what happens, my lord, subsequent to search, notices are issued, my lord, asking him to file the returns. Then the assessments are open. So the language used, my lord, here is where the registration or provisional registration of the trust or institution has been granted under so and so, and subsequently the principal commissioner or commissioner has noticed occurrences of one or more specified violations during any previous year, the commissioner or commissioner shall, I'm going to another, Lord says, pass an order in writing cancelling the registration of such trust or institution after affording a reasonable opportunity of being heard for such previous year.
Such previous year cannot be anterior to the Amendment Act.
It could be, my lord, if the assessment is open. What happens in cases of search is assessments are opened.
In other words,
it's not
One
concluded
second.
in, sorry.
why can't you stop? You interfere when we start thinking. In other words, where law takes note of an event is one thing. Merely because of that, it is not retrospective. Appears to be your submission. It takes an event anterior to coming into force. For example, all persons who are major as per the Indian Majority Act 1875, they will have a right to vote. Means all those who are already majors and all those who will become majors, both are covered under the contention.
Here, the specific case is, my lord, once the search is conducted as notice is issued,
It is
That-
reopened.
it's reopened, it's on. It's an assessment, fresh assessment.
Let issue emergent.
It's a pure question of law, my lord, I've raised.
On consider call after service agidena notice emergent notice admitted on the following substantial question of law, issue emergent notice. Yes.
Here, my lord, the Commissioner of Income Tax has exercised his powers, my lord, under 263 of the Act. Revisional powers, my lord, bestowed under 263 of the Act, my lord, wherein order passed by the transfer pricing officer is set aside for fresh consideration. The reason given is, my lord, explanation 2 of 263 says, my lord, may I read 263%?
Yes. Page number?
Page number, my lord, 1339. 1.1339.
1.1.
1341 can be seen, explanation. 2. My lord, I am reading 2024.
Tax Act,
24.
ಅಷ್ಟೇ complicated, ನೀವು ಅಷ್ಟೇ complicated.
1.1341.
1339. ಕಾಸ್ಮಿಕ್ ಜರ್ನಿ ಮಾಡ್ದಂಗ ಆಗ್ತದೆ. Ah, 1339. Yes.
Lord, revisional orders ಕೆಳಗೆ 263.
Correct.
Then, my lord, the next page, explanation 2.
Call for and examine, for etc. Explanation 2. For the
purpose of this section, it is hereby declared that an order passed by the assessing officer or transfer pricing officer, as the case may be, shall be deemed to be erroneous insofar as it is prejudicial to the interest of the revenue, if, in the opinion of the principal commissioner, the order passed is without making enquiries or verification which should have been made. The order passed is allowing any relief without inquiring into the claim. So in A, my lord, if the order is passed without making enquiries or verification which should have been made,
that becomes an erroneous order where revisional jurisdiction can be
Please.
exercised. Is the inquiry ಮಾಡಿರಲಿಲ್ವಾ?
I'll come to the directly, my lord, point, my lord, page number.
So
My lord, page, I'll come to the observations of the commissioner, my lord, page number
263 explanation
2.
A.
Yeah.
2A. ಯಾವ್ದು?
263, my lord.
ತೋರ್ಸಿ.
I'll come to the page number 192. My lord, wherever, my lord, this is a case where the employees were given, my lord, an employee stock option plan.
Employees were given.
Employee stock option plan. My lord, they are given stock at a discount right? They can make an option if whether they want to take it or not. So the difference will not in the actual price and the price at which, cost at which it is given, whether it should be treated as operating cost.
18
Determine arm's length price. I'll come to the observation, directly whether those enquiries have been made or not. Para 15.
Besides,
Besides, it is seen that at page 1, 2 of the show cause notice, the transfer pricing officer referred to in the financials of the SSC for the year as per a transfer pricing document, and at page 3, the transfer pricing officer computed the operating profit and operating cost of the SSC without any reference to ESOP cost. The operating revenue and operating cost computed by the SSC was accepted by the transfer pricing officer in the show cause notice itself, with the TP adjustment proposed on the basis of defects noted by the TPO in the TP analysis of the SSC in relation to the filters and comparables. Thereafter, a separate standalone general inquiry at page 21 of the show cause notice, along with the other costs relating to secondment, travel, management fees, communication assets, etc., details of cost of stock incentive plan, employee stock option plan were sought, including whether the said item has been included in the operating cost of the year. Wide reply so and so, the SSC gave its submission on the queries raised in the show cause notice, including as to why RSU cost is not operating in the nature and cannot form part of the operating cost. However, there were no further in-depth inquiries which were required to be made regarding the correctness or otherwise of the explanation of the SSC regarding the basis for which exclusion of ESOP cost from the operating expenses. An inquiry of general nature is distinct from the mandatory requirement of inquiry in as much as the latter requires detailed examination, verification of a claim before it is allowed. Hence, this is not a case where the transfer pricing officer has allowed the claim after being satisfied with the explanation of the SSC, but a case where TPO accepted the operating cost based computation of the SSC without verifying the material items, which are prima facie likely to have significant bearing on the determination of the arm's length price and failing to make verification of the allowability of the SSC's explanation. The present case is not one of the substitution of the TPO's opinion by the CIT's opinion as contended by the SSC, since the TPO had not formed an opinion, informed opinion in the first place on the inclusion or otherwise of shared based compensation in the form of ESOP cost in the operating cost pursuant to the inquiries, verification, and based on a detailed examination of the explanation of the SSC. The mere fact that ESOP cost details were sought as general item in the show cause notice does not imply detailed inquiries, particularly since at the outset of the TPO had accepted the cost-based SSC of the SSC wide the same show cause notice. The acceptance of the operating cost computation by the TPO without examining the specific items which had been excluded by the SSC to arrive at such computation constitutes an erroneous assumption of facts and correct application of the TP law, which makes the said order erroneous and prejudicial in the interest of the revenue. Then, my lord, in para 18, my lord, I'll just read, regardless of the Indo-AS
section, paragraph 15 nalli ಒಂದು ಲೆವೆಲ್ ಆಫ್ ಎನ್ಕ್ವೈರಿ ಹೋಲ್ಡ್
ಮಾಡಿದ್ದಾರೆ.
ನಿಮ್ಮಲ್ಲಿ ಡೀಪ್ ಎನ್ಕ್ವೈರಿ ಹೋಲ್ಡ್ ಮಾಡಬೇಕು ಅಂತ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ 2 ಕ್ಲಾಸ್ ಎ ಏನಂತೆ ಎನ್ಕ್ವೈರಿ ಮಾಡಬೇಕು ಅಂತಿದೆ.
What ought to have been?
What correct? What in his wisdom he sent notice, then reply was received, that was considered, then he arrived at a decision. Why deep inquiry ankondi alli where is the mandate?
Like that? Further, the Milord, the commissioner also refers to the judgment of this honorable court, where it was held, this cost, Milord, has to be treated as the operating cost of the SSC while determining it. That has had to be examined by the officer. The cost incurred by the
further inquiry ಮಾಡಿದ್ರೆ ಅಲ್ಲಿ ತನಕನೂ ಹೋಗ್ಬಿಡ್ತಿತ್ತು. ಅದು ಮಾಡಿಲ್ಲ ಅನ್ನೋದು. Let us see how explanation 2 item A reads in 263.
For the purpose of this section, it is hereby declared
All right.
that
The order is passed. Ek hogi, sak.
which should have been made
Is passed without making inquiries
or
or
verification.
verification, which should have been made.
Which
Verification
should have,
ಮಾಡ್ಕೊಂಡಾರೆ.
which should have been made means an item regarding which an inquiry should have been made. My lord, to say that it has to be included or not, a finding has to be arrived at. A show cause
ಇಲ್ಲಿ
notice
admission
is sent.
ಬಂದಿದೆಯೇನ?
Yes,
Admission-
Your Lordship. Senior counsel, Mr. Ajay Gora is appearing online. Your Lordship.
Yes. Requires consideration.
My lord, can I come in?
Yes.
My lord,
Yes,
can I
sir.
make my submission, my lord?
Yes, sir.
My lord, I will want to show my lord the facts first and then come to this question. Kindly have the tribunal's order, my lord.
But
In
this
the
is in
tribunal-
admission. This is in
Yes, my lord,
admission
so I'm
stage now.
objecting, my lord, I'm objecting that there is no substantial question of law. Because as my lord saw the opening words of section 263, one, the order must be erroneous and it must be prejudicial to the interest of revenue in order to assume jurisdiction under section 263 is the mandate that has been laid down by the apex court in repeated judgments. Explanation
ಇದು
2
notice
says,
ಆಗಿ ಬಂದಿದೆಯೇನು?
Admission.
Notice ಆಗಿ ಬಂದಿದೆ. We will
explanation
fix
2,
a date for hearing itself.
Please,
Question frame
I have,
ಮಾಡಿಲ್ಲ. Frame ಮಾಡಿವಿ.
ಮಾಡ್ಬೇಕು.
ಮಾಡಿಲ್ಲ.
ಇಲ್ಲ.
No, he says, question will not arise at all.
It will,
He
my
will
lord.
not arise, my lord.
It can
Question
be
will not
posted to
arise.
you.
This is settled, my lord, by several judicial judgments, and I will show the facts of this case. In fact, I have not claimed a deduction for this amount because this ESOP is given by my parent company to my employees. It is not my cost. I have not reimbursed the parent company. I have disallowed this amount that was debited to the profit and loss account while computing my taxable income. So this does not become part of the operating cost base. And that is why this has not been taken for transfer pricing purposes. This has been recorded in the order of the tribunal. I have judgments to support this. So the order which is in line, the order of the TPO, which is in line with the judgments passed by the tribunals, which have taken a view that where the cost is not absorbed by the Indian entity, it does not become part of the operating cost base. The judgment of the TPO being in line with those decisions cannot be said to be erroneous, much less prejudicial to the interest of revenue. And the record showed that the TPO raised several inquiries, is conscious of this fact, and then came to a conclusion that this will not form part of the operating cost for purposes of transfer pricing. And on the second issue, the two items, 228 million, the commissioner himself says these should prima facie not form part of the cost base, but he still goes ahead to pass an order under 263. So I'll be objecting, my lord, to the admission. My lords can fix it for hearing. I will make good my submission.
Very good.
May I make one submission? My lord? All that the commissioner had said at the end is, my lord, he directs the transfer pricing officer to rehear the matter on this
ಅಲ್ಲ, but
and
there
pass
is a-
fresh orders.
There is a prima facie consideration. Number one. And that senior advocate is pointing out, even under explanation B, it goes against you.
Good, I'll argue.
So we'll fix a date, then we'll see that. Which date will be convenient to you, sir?
Any date, my lord, that is convenient to my lord, I'll be happy to assist, my lord.
In the second, third week of March, I believe. Within few minutes, we are coming back.
Please, my lord. हमारी तो डेट ही लगी है, बंद कर दो, चल भाई.
Some other names also are there. We want this name to be- Okay. Third week of March, no? Any date given? Monday to Friday. Thank you. It's given third week of March, any day between, any day between Monday to Friday, it will come.
ಇಲ್ಲ ಕೊಡ್ತೆ ಕೊಡ್ಸಿ. ಇನ್ನೂ ಇದೆಯಾ? ಯಾರು? ಎಲ್ಲಿ ಮೇಡಮ್? ಮೇಡಮ್ ಪ್ರೈವೇಟ್ ಕೆಲಸ ಮಾಡಿ.
Yes.
Lord, the facts of the case is, my lord, a search came to be conducted in the group case of, my lord, Nirav Modi.
Notice. Notice open.
Appear for respond number 3. Directors of respond number 3 are present before the court as directed by this court.
They are present here.
Yes, my lord.
For a passover,
And my lord, let it pass over, I have no problem. I will explain to court what happened, my lord.
What was the order other day? We'll go to Raghavan's argument afterwards.
Yes.
What was the undertaking you had given to us?
to execute 54 sale deeds, ma'am. We have the 54 sale deeds with us.
You have brought them?
Yes, ma'am. We brought the 54. My lord, there is, what has happened is, insofar as 32 apartment owners are concerned, ma'am, we were able to obtain the agreement from them. Insofar as they are concerned, ma'am, sale deed is clear in all aspects. So for the remaining people, there are some discrepancies insofar as the cital area, etc. That, my lords, I think me and Mr. Lakshmish will have to sit and sort it out because small minor things are there. But we have
about the 32 people.
we have all 54. We've executed sale deeds.
Yeah, they have executed sale deed now.
Yes.
They
No,
are
I
they
signed and
clear?
signed and obtained, signed and I have it here, my lords. I have
Have
the-
signed it.
Yes, I have signed it and I have it.
That they have to sign.
They have to sign it. Yes.
ಯಾರು ಇದಾರ ನಿಮ್ಮ clients ಯಾರು ಇದಾರ?
The sale deeds have, the draft has been provided to me late last night.
Ah.
There are certain discrepancies insofar as the boundaries and measurements of the composite property is concerned, as well as the undivided share that has been sold. That apart, the draft is taking away the rights of home buyers to seek compensation as against the firm also at a later point in time for the delay of more than 1.5 decades. That needs to be discussed with them.
We
They
have
should not, in
we'll
the
make
guise
a-
of completion of the project, in the guise of execution of the sale deed, they should not take away my legal rights, which I've been fighting for the last 15 years.
ಎಲ್ಲಿದ್ದಾರೆ ನಿಮ್ಮ ಕ್ಲೈಂಟ್ಸ್ ಯಾರು ಇದಾರ ಇಲ್ಲಿದ್ದಾರೆ ಎಲ್ಲರೂ ಕರೀರಿ ಅವ್ರಿಗೆ ಅಟ್ಲೀಸ್ಟ್ ಆ ಕಂಡೀಷನ್ ಹಾಕ್ಬೇಡಿ ಅವ್ರು ಬೇಕಾದ್ರೆ ಫೈಟ್
My
ಮಾಡಿಕೋತಾರೆ
lords, insofar as eternity is concerned,
let them file
yes.
let them claim
Huh.
that claim will be against rest of the directors. Why are you worried about
My lords, my lords, exactly. My lords, what he's saying is, my lords, what has happened is there is an agreement between me and Eternity, which is respondent number 2, under which I was supposed to get 40 flats. What Eternity and the home buyers are saying, the land belonged to me. Eternity was brought in only for the purpose of putting up construction. Eternity does not put up construction, puts up a structure and escapes with all the money of all the persons. Now, Consumer Forum catches hold of me, I undertake, I give a bank guarantee, I put up the construction, spend 15 crores of my money, put up the construction. Now, my lords, what everybody is saying is that Eternity per se does not have any money. We will attach the property belonging to the firm, which is the 40 flats actually falling to my share. And that those 40 flats, my lord, they will recover the money from. That, my lords, is virtually taking whatever benefit that I would have got under the contract by putting up the construction, takes away that. And under the agreement between the parties, my lord, which I have produced, for insofar as his 60 flats are concerned, 59 flats are concerned, he is completely responsible. Insofar as my 40 flats are concerned, I am entitled to enter into agreement with any person. That right will go away because of this. And I was not made a party in the original proceedings where I could have brought all of this on record.
that's all right. Now, so far as the fault is concerned,
Yes.
against whomsoever fault lies,
Yes, my lords.
against those people, they will proceed.
My lords, I'm saying Eternity. I'm saying that it should go against Eternity and not against
My lord.
not against the firm's property.
The agreements have been executed by the
Then
parties.
we'll admit this matter, let them wait another 10 years. My object was to see that they get the site in their lifetime.
Yes,
Because otherwise they will not get it. We know the court process. I'm sorry, as a judge, I should not say that. It will take another 10 years. Admittedly, he is not a party, so you cannot proceed against him. So you have to proceed against others,
against the firm.
And therefore, as against him, we will quash the proceedings and leave it as it is.
Lords, as against
Ask whether your clients are agreeable to this proposal.
So long as our rights to seek.
Ask your client, they are here. The lawyer should resist their temptation to argue the matter. Instead, they should be after getting justice to their client. 10 ವರ್ಷ ಆಗಿದೆ ಅವ್ರು ದುಡ್ಡು ಕೊಟ್ಕೊಂಡು ಇವತ್ತಿಗೂ ಸೈಟ್ ಸಿಕ್ಕಿಲ್ಲ ಅಂದ್ರೆ ಎಷ್ಟು ವರ್ಷ ಬದುಕ್ತಾರೆ ಇವರೆಲ್ಲ? ಮೊದಲು ಕೇಳಿ ಅವರಿಗೆ, ಮೊದಲು ಸೈಟ್ ತೊಳಿಕ್ ಹೇಳಿ.
My lord.
ದಡ್ಡತನ ಮಾಡಬೇಡಿ. ಸ್ವಲ್ಪ ಅರ್ಥ ಮಾಡಿಕೊಳ್ಳಿ. As a judge, we are telling we have abundant experience with builders. ನೋಡಿ, ಒಂದು ಶ್ಲೋಕ ಇದೆ. ವಿನಾಶಕಾಲೇ ಸಮುತ್ಪನ್ನೇ ಅರ್ಧಂ ತ್ಯಜಿತ ಪಂಡಿತಃ. When one is losing everything, one who saves half is pandita, intelligent man. You all appear to have crossed at least 50, if not 60. How many years you want to fight? First, get the site. Get the building first. Gain entry to that building. Sleep and dream there first. Then rest of the things will happen. Otherwise, your life will go in court proceedings. Don't do it. With lot of tactics and pressures, we have done something so that you will have your house at this age at least. Because you go and ask your spouses over phone, judge is saying like this, whether we should agree or not. See what she will advise. ನಿಮ್ಗೆ ಬಿಟ್ಟಿದ್ದು ನೋಡ್ಕೊಳ್ಳಿ. ಇಲ್ಲಪ್ಪ ನಾವು ಇದನ್ನ ಅಡ್ಮಿಟ್ ಮಾಡಿರ್ತೀವಿ, ಅದು ಹಿಯರಿಂಗ್ ಬರ್ತದೆ ಒಂದು 6-7-8 ವರ್ಷದೊಳಗಡೆ. ಮುಂದೆ ಏನೇನಾಗ್ತದೆ ಗೊತ್ತಿಲ್ಲ. Think about that. On the other hand, he has brought the sale deed because we made him to undertake to give undertaking to us. ವಿಚಾರ ಮಾಡಿ. ನಾವು ಪ್ರೆಷರೈಸ್ ಮಾಡ್ತೀನಿ ಅಂತ ತಿಳ್ಕೊಬೇಡಿ. ನಮ್ಮ ಅನುಭವದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ನಿಮ್ಗೆ ಹೇಳ್ತಾ ಇದ್ದೇವೆ. ನಮ್ಮ ಅನುಭವದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಇದನ್ನ ನಾನು ನಿಮ್ಗೆ ಹೇಳ್ತಾ ಇದ್ದೇನೆ. ನಿಮ್ ಕ್ಲೈಂಟ್ ಇದಾರನು? ನಿಮ್ ಕ್ಲೈಂಟ್ ಸ್ವಲ್ಪ ಹೊರಗಡೆ ಇರ್ಲಿಕ್ಕೆ ಹೇಳಿ. Kindly be waiting outside. We'll invite you again inside. Okay. ಬಾಗ್ಲ ಹಾಕಿ.
Respond number 3.
ಇಲ್ಲಿ ಬೇರೆ ಯಾರಾದ್ರೂ ಬಿಲ್ಡರ್ಸ್ ಇದಾರನು?
Respond number 3.
ಬಿಲ್ಡರ್ ಅವ್ರಿಗೆ ಹೊರಗಡೆ
ಹೊರಗಡೆ
ಇರ್ಲಿಕ್ಕೆ. ಈಗ ನಾನು ಒಂದು ನೀವು ಒಂದು ನಿಮಿಷ ಅವ್ರ ಜೊತೆ ಮಾತಾಡ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ ತಾವು ಮಾತಾಡಿದ್ರೆ
ನಾವು ಮಾತಾಡಿದ್ದು ನೀವು ಅವ್ರು ಏನ್ ತಿಳ್ಕೊಂಡಾರ ಅಂತ ಗೊತ್ತಾಗಬೇಕಲ್ಲ ನಮ್ಗೆ. ಒಬ್ರ ಜೊತೆ ಮಾತಾಡ್ಕೊಳ್ಳಿ. BBMP ಅವರು ನಿಮ್ಮ ಇದನ್ನು ಕೊಡೋದಿತ್ತಲ್ಲ,
ಈ ಖಾತಾ
ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ?
Taxes and improvement taxes charges are not being paid. Number 3, is under construction, so they have to apply for a partial OC.
ಹಾಕಿದ್ದಾರೆ, ಅಪ್ಲೈ ಮಾಡಿದ್ದಾರೆ.
ಅಪ್ಲೈ ಮಾಡಿ ಆಗಿದೆಯಾ? ಮಾಡಿದ್ದೀರಾ?
The files, so that's what they are. We were served with a copy day before, sir.
ಒರಿಜಿನಲ್ ಫೈಲ್ ತರಿಸಿ ಈಗ.
Please. That's it.
ಅರ್ಧ ಗಂಟೆಯಲ್ಲಿ ಇರಬೇಕು ಒರಿಜಿನಲ್ ಫೈಲ್, ಇಲ್ಲ half an hour naga original file. Otherwise I will issue arrest warrant against the commissioner. Yes, tell him. ಅರ್ಧ ಗಂಟೆಯಲ್ಲಿ ಇರಬೇಕು ಇಲ್ಲಿ ಫೈಲ್. ನಿಮ್ ಪ್ರಪೋಸಲ್ ಹೇಳಿ. ಈಗ ನೀವು ಸೇಲ್ ಡೀಡ್ಸ್ ಅನ್ನ ತೊಗೊಂಬಂದಿರಿ.
ಕೊಟ್ಟಿದೀವಿ
ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಟ್ಟಿರಾ? ಕಾಪಿ ಯಾವ ಕ್ಲಾಸ್ ಮೇಲೆ ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ತೋರಿಸಿ ಅಂತ ಹೇಳಿ. ಯಾರು ಗೊತ್ತಿದ್ದಂತವ್ರು ಮುಂದ್ ಬನ್ನಿ. ಯಾವ ಕ್ಲಾಸ್ ಮೇಲೆ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ಅವುಗಳನ್ನ ರೀಕ್ಯಾಸ್ಟ್ ಮಾಡಬಹುದಾ ಹೇಳಿ. ಅಬ್ಜೆಕ್ಷನ್ ಇರೋ ಕ್ಲಾಸ್ ನಮಗೊಂದು ಕಾಪಿ ಕೊಡಿ. ವೆರಿ ಗುಡ್ ದಟ್ ಯು ಹ್ಯಾವ್ ಬ್ರಾಟ್ ಒರಿಜಿನಲ್ ಸೇಲ್.
My learned friend.
Of course, I know him. That's why. ಒಂದು ಸೇಲ್ ಡೀಟ್ ಕೊಡಿ ನಮ್ದು. ಎಲ್ಲ ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಫಾರ್ಮ್ಯಾಟ್ ಇದೆಯಾ?
ಎಲ್ಲ ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಫಾರ್ಮ್ಯಾಟ್ ಸ್ವಾಮಿ.
ಒಂದ್ ಸಣ್ಣ ತಪ್ಪು ಮಾಡಿರಿ ನೀವು. ಇದನ್ನ ಮಾಡುವಾಗ ಅವ್ರ ಕಡೆಯವ್ರು ಒಬ್ಬರನ್ನ ಕರೆದು, ನೋಡಯ್ಯ ನಾವ್ ಈ ರೀತಿ ಮಾಡ್ತಾ ಇದೀವಿ, ನಿಮ್ದು ಏನಾರ ಸಜೆಷನ್ ಇದ್ರೆ ಕೊಡು ಅಂತ ಕೇಳಲಿಕ್ಕೆ ಬರ್ತಿತ್ತು. ಎನಿವೆ ಇಟ್ ಹ್ಯಾಸ್ ಹ್ಯಾಪನ್. ಲೆಟ್ ಅಸ್ ಸಿ.
ನಿಮಗೆ ರಿಸರ್ವೇಶನ್ ಇದೆ ಸರ್?
Paragraph 5.
Paragraph 5. The memorandum of agreement further provides that Messrs. Utility Developers shall have the right to sell the units allocated to it and shall bear full responsibility towards the buyers of such units, notwithstanding that the sale transaction shall be executed in the name of the party. ಏನಿದೆ ಇದರಲ್ಲಿ?
ಕಡೆಯಲ್ಲಿ
ಅವ್ರ ಮೇಲೆ ಬರಬಾರ್ದು ಅಂತಿದೆ.
ಕಡೆಯಲ್ಲಿ purchasers hereby declare and confirm that they shall have no claims, including for any damages, interest, etc., against High Point Finance Private Limited, either directly or through the partnership firm, Mrs. Waterfront Developers.
ಅವ್ರ ಅಗೇನೆಸ್ಟ್ ಬೇಡ, ಇಷ್ಟೆಲ್ಲ ಮಾಡ್ಕೊಡೋರು ಯಾರು?
ಅಲ್ಲ, ಆರ್ ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಫರ್ಮ್ ಅಂತ ಹೇಳಿ.
ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಫರ್ಮ್ ಮೇಲೆ ಹೋಗ್ಕೊಳ್ಳಿ ಅವರು.
True. We are only saying, my lord.
ಈಗ ಇವ್ರು ಕೊಡ್ತಾ ಇರುವಂತ ಇವ್ರ ಇಂಟ್ರೆಸ್ಟ್ ಏನಿದೆ ಅಲ್ಲಿ, ಆ ಇಂಟ್ರೆಸ್ಟ್ ಗೆ ನೀವು ಎಕ್ಸಾನರೇಟ್ ಮಾಡ್ಬೇಕು.
40 lakhs.
You proceed.
Please.
If they want to proceed against him, let them proceed.
My lord, land is standing in the name of the firm.
In the name of
firm.
ಹಂಗೆ ಕೊಡ್ತೀವಿ.
Documents have been executed in the name of firm.
Correct, ಕೊಡ್ತಾ ಇದೆ.
Case has been filed against the firm. Orders have been passed against the firm.
Without the partner.
Yes, without the.
As against
against
him.
the partner.
As against him.
Yes.
And as against the interest which he has in the firm. ಅದನ್ನ ಬಿಟ್ಟುಕೊಡಿ. Rest of the things on ಮೇಲೆ proceed ಆಗಿ.
The first instance, your my lord,
ನಿಮ್ ಕ್ಲೈಂಟ್ ಹೋಗ್ತಾರೆ ಎಲ್ಲ ಕೇಳ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ, ಅವ್ರು ಹೇಳಿದ್ರು, I have got the instructions. They wanted this week.
Those two people have been declared to be proclaimed offenders.
My lord, it's withdrawn. They have appeared. This is not correct, my lord.
ಬಂದಿದೆ ಸರಿ, but after the direction of the court.
And long back in 21, it was withdrawn, my lord. They are appearing regularly.
ಅವ್ರಿಗೆ ಕುತ್ಕೊಳ್ಳಿಕ್ ಹೇಳಿ. ಅವ್ರೇನು ಅಕ್ಯೂಸ್ಡ್ ಅಲ್ಲ, ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್. Ask them to sit down.
Proclaimed offenders ಅಂದ್ರೆ
I will show, my lord, from the proceeding before tribunal. I am also a victim. I am not a perpetrator. I will show. I am permitted to file on small dates and events. I will show from documents.
ನಿಮ್ ಪಾರ್ಟ್ನರ್ಸ್ ನಲ್ಲಿ ನೀವೇನೇನೋ ಮಾಡ್ಕೋಬೇಕು, ಅದು ನಮ್ ಕನ್ಸರ್ನ್ ಅಲ್ಲ. ಕನ್ಸ್ಯೂಮರ್ಸ್ ನಮ್ಮ ಮುಂದಿದ್ದಾರೆ.
Problem ಏನಂದ್ರೆ allegation is against me.
My lord, the cause for
allegation in the petition is against me, my lord. Therefore, I had to say. Otherwise, prayer is not against, but allegation is against me. And I could not develop only because the khata obtained by them is different.
Second, ಈಗ ಅವ್ರು ನಿಮಗೆ ಸೇಲ್ ಡೀಡ್ ಮಾಡಿ ಕೊಡ್ತಾ ಇದಾರಲ್ಲ, ಅವು to the extent of his alleged responsibility, you exonerate him. Everything will be.
He wants me to remit the balance sale consideration. He is demanding that from me.
ಬ್ಯಾಲೆನ್ಸ್ ಕೊಡಬೇಕಲ್ಲ?
Yes, ಅದು ಕೊಡಬೇಕು. he is not ready to take the responsibility of paying the
ನಾವು
delay
ನಾವು
compensation.
ಕಂಪ್ಲೀಟ್
So be it.
ಮಾಡಿದ್ದೀವಿ ಸರ್ ನಮ್ಮ ಮುಂದಲ್ಲಿ
99 ಯೂನಿಟ್ ಇದೆ, 55 ಮಾರಿದ್ದಾರೆ, 40 ಇವ್ರು ಇಟ್ಕೊಂಡಿದ್ದಾರೆ, ಇನ್ನು 4 ಎಕ್ಸಿಕ್ಯೂಟಿಂಗ್ ಪಾರ್ಟ್ನರ್ ಇದೆ. Fact remains that the apartment is not complete. I have furnished the photographs. ಅದು ಬಿಟ್ಟುವೆ
ಕಂಪ್ಲೀಟ್ ಆಗಿಲ್ಲ. ಆಗಿದೆ
I will undertake.
Instructions ಎಲ್ಲ ಆಗಿದೆ.
Right now, if it is complete,
ಕಳಿಸಿಬಿಡ್ತೀವಿ.
yes, yes.
I
have furnished the
I will tell
photographs.
your lordships, my lord, the order of the commission was that the building must be completed, and if it is not completed by the opposite parties 1 and 2, the complainants themselves can complete it and recover the money. Now, my lord, because of all these execution orders where I was roped in, I have completed it with my cost. Therefore, I ask myself, am I unreasonable in saying whatever is, even if it is 10 rupees which is outstanding under the agreement, give it to me, because I have spent money from my pocket for the purpose of completing your building. So why am I said it's unreasonable request? I'm not saying money which you have paid, you got to give it to me. No. ಯಾವ್ದು ಬಾಕಿ ಇದೆ, 10 ರೂಪಾಯಿ ಬಾಕಿ ಇದೆ, 10 ರೂಪಾಯಿ ಕೊಡಿ.
ಅವ್ರಿಗೆ ಮನೆ ಬಿಲ್ಡಿಂಗ್ಸ್ ಎಲ್ಲ ಯಾವತ್ತು ಹೋಗಿದ್ರಿ ನೀವು?
2 weeks, 3 weeks back.
ಇತ್ತೀಚೆಗೆ ಹೋಗಿಲ್ಲ.
Almost 3 weeks.
ಅದೇ ನಮ್ಮ ಪ್ರಶ್ನೆ ಕರೆಕ್ಟ್ ಉತ್ತರ ಕೊಡಬೇಕು. ಕನ್ನಡ ಅರ್ಥ ಆಗ್ತದ? Do you understand ಕನ್ನಡ?
Yes.
Yes. ಇತ್ತೀಚೆಗೆ ಒಂದು ವಾರದ ಹಿಂದ್ಗಡೆ ಅಲ್ಲಿಗೆ ನೀವು ಹೋಗಿದ್ದೀಯಾ ಯಾರಾದ್ರೂ?
ಇಲ್ಲ.
ಈಗ ನೀವು ಕಂಪ್ಲೀಟ್ ಮಾಡಿದ್ದೆ ಯಾವಾಗ? When have you completed the construction? 2024, 2022, complete.
All these flats which are to our share, some interior works we've not completed.
Forget about it, your flat.
Whatever has been sold has been 100% completed.
ಇಲ್ಲಿಂದ ಎಷ್ಟು ದೂರ ಆಗ್ತದೆ?
14 kilometers.
14 kilometers.
ಒಬ್ಬರು ಕಮಿಷನರ್ ಅಪಾಯಿಂಟ್ ಮಾಡಿಬಿಟ್ಟು ತಮ್ಮ ರಿಪೋರ್ಟ್ ಹಾಕಿ.
Aditya, can you just go to the building along with BBMP lawyer Kartikeyan, both of you,
And
take one lady also, 3 persons.
and my learned friend and the developers ಎಲ್ಲ ಹೋಗಿ ತೋರಿಸ್ಬಿಡ್ಲಿ, ಇವ್ರ ಕಡೆ ಯಾರು ಬರ್ಲಿ, ಎಲ್ಲರೂ ಬರ್ಲಿ.
ನೀವು ಕರೆಕ್ಟ್, ನೀವು ಹೋಗಿ.
ನಮ್ದು 40 ಆಗಿಲ್ಲ, ಅವ್ರದ್ದು 50 ಆಗಿದೆ, 60 ಆಗಿದೆ. That is the statement that has been made before your lordships. My lord, there is a distribution.
ಅವ್ರ ಸ್ಟೇಟ್ಮೆಂಟ್ ಬಿಡಿ, ನೀವು ಹೇಳೋದು ಹೇಳಿ.
ಅವ್ರದ್ದು whatever has been sold to them, the instructions are 100% completed. ನಮ್ದು 40 ನಾವು ಮಾಡಿಲ್ಲ, ಮಾಡ್ಕೋತೀವಿ ನಾವು ಯಾವಾಗ.
ನಿಮ್ದು 40
ಆಗಿಲ್ಲ.
ಈಗ ಇಲ್ಲಿರೋರಿಗೆ 40 ಎಲ್ಲಿ ಬರ್ತದ, 50 ಎಲ್ಲಿ ಬರ್ತದೆ?
ಅವ್ರದ್ದು 50.
ಅದನ್ನ ನೀವೇ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿ ಕೊಡ್ತೀರಾ?
ಹೌದು.
ಸೇಲ್ ಡೀಡ್.
That was your lordship's order.
ಅಲ್ಲೇ ನಿಮ್ ಕ್ಲೈಂಟ್ ಎಲ್ಲಿದ್ದಾರೆ ಕೇಳ್ರಿ ಅವ್ರು. ನಿಮ್ ಕ್ಲೈಂಟ್ ಎಲ್ಲಿದ್ದಾರೆ? ಯುವರ್ ಕ್ಲೈಂಟ್ಸ್, ಆಸ್ಕ್ ದೆಮ್ ವೆದರ್ they are ready to, they are agreeable with the sale deed.
They are agreeable, madam.
Consenting ಅಲ್ಲಿ ಕನ್ಸೆಂಟಿಂಗ್ ವಿಟ್ನೆಸ್ ಹಾಕ್ಬೇಕು ಅದಕ್ಕೆ.
My lord, we are not, the draft has not been shared with us. Insofar as, my lord, I'll say what is the concern, my lord. They had initiated an arbitration against us saying we have caused loss, that arbitration.
ಎಷ್ಟು ವರ್ಷದ ಹಿಂದೆ ದುಡ್ಡು ಇಸ್ಕೊಂಡಿತ್ತು? ದುಡ್ಡು money was taken by your clients how many years back?
Not by our clients, by the firm in 2000, from 2009 to 12. They have withdrawn money from the firm account. I have account statement where they have withdrawn some amount. I have used for development.
Have you remitted this money back to the consumers?
My lord, no, my lord, it was used for development.
Answer our question. Don't mislead us.
No, my lord, it was used
You
for
have not
development.
given back the money to consumers.
No.
So money is being circulated amongst the partners, is your case.
It was,
But it is not circulated with them.
yes, my lord. Yes, my lord.
For your fault, why should the buyers be put to problem?
They should not, my lord. They should not.
Therefore, execute the sale deeds first.
Yes, my lord. That is the instruction also, my lord. We are ready to execute the sale. We had no power under the document, my lord. Otherwise, we would have done it long back.
13 ವರ್ಷ ಆಗಿದೆ.
ಅಲ್ಲ,
2012 ಟ್ರಾನ್ಸಾಕ್ಷನ್.
ನಮ್ಮಲ್ಲಿ ಇಂಜೆಕ್ಷನ್ ತಗೊಂಡ್ರು.
They are the ones who signed it.
ಅಲ್ಲ,
signed the agreements.
16 ಅಲ್ಲಿ ನಮ್ಮಲ್ಲಿ ಇಂಜೆಕ್ಷನ್ ತಗೊಂಡ್ರು. Arbitration ನಮ್ಮಲ್ಲಿ not to alienate any properties ಅಂತ ನಾವು
ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಏನಾಗಿದೆ?
ಇಲ್ಲ 2014 ಅಲ್ಲಿ I applied for OC in respect of some apartments. By completing, consumer complaint started. The address of respondent number 2 firm is that of the petitioner here, my lord, same address number 45 in all 24 complaints.
ಹಿಂದಿನ ಬಿಡಿ.
And my lord, they did not appear.
All right. ಈಗ ನೀವು ಸೇಲ್ ಡೀಡ್ ಮಾಡಿ ಕೊಡ್ತೀರೋ ಇಲ್ಲ?
My lord.
Ask your client.
We are ready, my lord. That is the instruction.
ಅವ್ರು ಕೇಳಿ ಒಂದ್ಸರಿ.
Ready, my lord.
ಸೇಲ್ ಡೀಡ್
Ready.
ರೆಡಿ.
Now, consumer forum, now we have not filed any appeal against the order also. We are ready.
ಮತ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಎಲ್ಲ ಯಾಕೆ ಮಾಡಿರ್ಲಿಲ್ಲ? ಇವ್ರು ಮಾಡುವಂಗೆ ಯಾಕೆ ಮಾಡ್ಕೊಂಡ್ರಿ?
My lord, ಇದು inter-alia dispute. I have produced statement of claim, statement of defense in the arbitration 2016 also, where I have said because of want of cooperation from them, I could not do it. Arbitrator tribunal eventually dismissed their claims in that matter. And they filed section 34, section 34 also dismissed.
ಅಲ್ಲಿ ಸೇಲ್ ಡೀಡಿಗೆ ಇಷ್ಟೊಂದು ಕ್ಲಾಸಸ್ ಹಾಕ್ಬೇಕು. ವೈ ದೀಸ್ ಕ್ಲಾಸಸ್? ಮಾರುವವರು, ಮಾರಲ್ಪಡುವ ವಸ್ತು, ಪಡೆಯುವವರು, ಕೊಡುವಂತ ಕನ್ಸಿಡರೇಷನ್, ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ, ಸ್ಟಾಂಪ್ ಡ್ಯೂಟಿ ಅಷ್ಟೇ ರಿಕ್ವೈರ್ಮೆಂಟ್. ಪೊಸಿಷನ್ ಬಂದು ಇಷ್ಟೇ.
Actually, my lord, I agree.
ಅಷ್ಟೇ ಮಾಡಿ.
My lord, essentially, it is a writ against me without prayer, so that they get all this and they will come after me. My lord. That's the concern.
227 ಇದು. 226, 227. You have seen the latest judgment last Thursday. We can do all that which the Supreme Court can do under 142.
Of course, old judgment,
agree.
my lord, it's there, been long,
Of
long.
course. Therefore, we don't want them to commit suicide. There is a limit where from they have brought money. It is not that they have robbed some bank or something like that. They have put their hard-earned money because of your dispute interest. You can't make the citizens suffer.
My lord, my only submission is
Our submission is execute the sale deed, then go to the battlefield as against your
yes, my
partner.
lord.
And,
I bow down to
and
the
I
court.
want to
My only
make-
submission.
Your lordship said, why all these clauses, my lord? My instructions are that this is in the format that is generally prescribed by RERA.
No, I dispute.
Where is fixed?
Yes, yes.
I dispute.
That's what.
Give that RERA code. Show that.
ನಾನು ನೋಡಿಲ್ಲ, my learned friend tells me.
No.
My lord, my only submission is we will cooperate, we are ready to execute sale deed. All questions between us partners and the firm may be kept open. That's all, so that any liability is not saddened on me by the petitioner.
No, I'm only saying no liability can be fastened on me. As between us, of course, it can be kept open, no difficulty. But if the buyers want to proceed, they must proceed against my learned friend's client, not against me.
In which case it will be open for me in law to
Of course,
claim
of
compensation
course,
from them if they are found fault with by the tribunal ultimately.
No objection to that submission.
I have one.
My lord, as between the two partners, we will fight it out independently. We don't want to trouble the buyers. My lord.
Correct.
But insofar as the buyers is concerned, about that 10,000 rupees, that all that is to be executed only against my learned friend's client, not against my client. Because I was not a party at any point of time. Therefore, my lord, all that I need your lordship's kind consideration is the two submissions. As between me and the other partners, my lord, we will fight it out independently. We will not bring that within the purview of this litigation. I understand, but I bow down to the what?
1 second. ಈ ಪ್ರಪೋಸಲ್ ನೀವೇನ್ ಹೇಳ್ತೀರಿ? ಅವ್ರೊಳಗೆ ಏನ್
My rights
ಮಾಡಿಕೊಳ್ಳಿ.
My rights to seek compensation as against the firm may please be protected.
Only against them.
My lord,
That
firm
is-
has
that-
properties.
My hum sub-
Last time, in fact,
out
that
of
was the issue.
99 units, 55 are sold, 40 is retained by them, 4 are retained by them. He is absconding. I can't even secure his presence, leave alone attach.
My lord,
Here,
This is my
order sheet ಇದೆ ತಮ್ಮ ಮುಂದೆ.
here, here.
ಅವ್ರದ್ದು 40 ಬಿಟ್ಬಿಟ್ರೆ ನಮ್ಮ as on today, even according to the order dated 31/3/2016, if I have to implement it, it would amount to 10 crores. How do I recover that money?
So, but he is not a party.
ಅಲ್ಲ, ಅವ್ರ ಮೇಲೆ ನಾನು ಕ್ಲೇಮ್ ಮಾಡ್ತಾ ಇಲ್ಲ. My rights to claim as against the firm may please be protected. That is
Firm
my
ಅಂದ್ರೆ
hum-
firm ಅಂದ್ರೆ ಬರಲ್ಲ ಅವ್ರು.
ಅಲ್ಲ, firm ಮಾಡ್ಕೊಟ್ಟಿರೋ
Number 2 is the firm party.
I have paid the firm has executed the sale
But
contracts.
whom you have made party before the consumer?
Firm is a party.
Orders passed against the firm.
Please understand. Read section 4.
Correct.
Please read section 4.
Property is
of
still
the
standing
partnership
in the
act.
name of firm, my lord.
All partners should be joined.
Yes, my lord.
but you
Yes.
have left him out.
ಅಲ್ಲ ಅವ್ರನ್ನ ಬಿಟ್ಟಿರೋದು I do not even want to prosecute him right now.
That's fine.
ಅಷ್ಟೇ ಹೇಳಿ, ಅಷ್ಟು ಬೇಕು ಮುಗ್ದೋಯ್ತು.
Partnership firm ಮೇಲೆ ಆರ್ಡರ್ ಇದೆ, I will implement as against you.
No, I
ಬೇರೆ ಇನ್ನೇನು
implement against
option
other
ಇಲ್ಲ.
partners. Please go ahead, do it. I will support you.
But see, he may not go against you. But once he proceeds against other partners, they may go for
That is,
contribution.
please leave that question open.
My lord,
No,
My lord,
whatever it is, I will.
my
fight
submission
the-
is the firm is held to be liable. Assets of firm are there.
Firm-
And my lord, I am broke.
Firm represented by two partners.
Yes, my lord.
Other partner is not a party.
Yes, my lord.
Therefore, they will implement that order as against your client.
My lord, but Article 21, Rule 50 of CPC permits inquiry by the court as to whether the other partner should be held liable or not.
That is provided they are party to the proceeding.
No, my lord, when they are not party.
Article 20,
Article 21, Rule 50 of CPC.
is it applicable to consumer disputes also? CPC is excluded.
But the principles will be applicable, my lord.
No. There is a provision in Consumer Protection Act which excludes CPC. If I am right, I do not know. At least there are such judgments. But Consumer Protection Act.
ಈಗ ಒಂದೇ ಒಂದು ಎರಡು ಶೀಟ್ ಕೊಟ್ರೆ ಏನ್ ಮಾಡ್ಲೆ?
I remember
ಒಂದು ತಿಳಿತಾ ಇಲ್ಲ ನನಗೆ.
in the context of
ಏನು?
DLT Act,
ನಿಮ್ ಜಗಳದಲ್ಲಿ ಅವ್ರು ಯಾಕೆ ಸಾಯ್ಬೇಕು ಅನ್ನೋದು ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ.
ಅದಾಗ್ಬಾರ್ದು.
ಅದಾಗ್ಬಾರ್ದು ಅಂತ
ಇಲ್ಲ,
13
ನಾನು
ವರ್ಷ ಆಗಿದೆ.
ಅಲ್ಲ, ನನ್ನ ಸಿಚುಯೇಷನ್ ಐ ವಾಸ್ ಬ್ರೋಕ್ ಮೈ ಲಾರ್ಡ್, ಅದರಿಂದ ಐ ಕುಡ್ ನಾಟ್ ಕಂಪ್ಲೀಟ್ ಆಫ್ಟರ್ ದಟ್, ಬಟ್ ಐ ಹ್ಯಾವ್ ಇನ್ಫಾರ್ಮ್ ದೆಮ್ ಆಲ್ ಅಲಾಂಗ್ ಇಸ್ ಮೈ ಕೇಸ್.
Yeah, my lord, kindly see the conduct of my learned friend's client. But for your lordship's order last time, they would not have been before your lordships. ಎಲ್ಲಿದ್ದಾರೆ ಗೊತ್ತಿಲ್ಲ, ಎಲ್ಲೋ ಇದ್ದಾರೆ.
Annexure A in one of the petition we seen, I am appearing regularly before State Commission. The
But
commission that they are proclaimed offenders today is in fact not a correct statement. There is
Recorded. It is recorded in the order.
ಅಲ್ಲ, ಆಮೇಲೆ ಅದು ಆಮೇಲೆ ನಾನು ಅಪಿಯರ್ ಆಗಿ ಸ್ಟೇಟ್ ಕಮಿಷನ್ ಮುಂದೆ ಐ ಹ್ಯಾವ್ ಅಪಿಯರ್ಡ್, ದೇ ಹ್ಯಾವ್ ರೀಕಾಲ್ಡ್, ಐ ಆಮ್ ಅಪಿಯರಿಂಗ್ ರೆಗ್ಯುಲರ್ಲಿ. Even as on May 2024 I have appeared.
Which is that section which says CPC is not
That's why I'm
applicable?
looking, my lord.
That judgment.
Kindly give me a minute, my lord. I will.
Section 13.
My lord, your lordship, give me a minute, my lord. I will. 26, huh? Section 26.
86 Act ಅಲ್ಲಿ
20?
6 ಅಲ್ಲ, ಅದು old act, no? Old act.
ಹೌದು, ಇದು ಓಲ್ಡ್ ಆಕ್ಟ್.
It comes under old act only.
ಓಲ್ಡ್.
ಎಲ್ಲಿದೆ? 26 ಆ? ಯಾವ್ದ್ರಿ? 24 ಆ? ಏನೇನೋ ಹೇಳ್ತಾರೆ.
ಸೇರಾ ಎಷ್ಟು ಮಾಡಿದ
ಇದೆಯಾ?
Rules are. Regulations. 26. My lord, kindly see, may I interrupt your lordship? Act ಅಲ್ಲಿ ಇಲ್ಲ, regulations ಅಲ್ಲಿ ಇದೆ.
ಇಲ್ಲ,
Regulation.
Regulation ಅಲ್ಲಿ, act ಅಲ್ಲಿ ಇಲ್ಲ ಸ್ವಾಮಿ.
Rules
Kindly
or regulation?
My lord, regulations, my lord.
ಹಾ.
Consumer Protection Regulations 2005 ಅಂತ ಇದೆ.
Correct.
ತಾವು ಅದರಲ್ಲಿ, if your lordships are kind enough to see regulation 26.
Miscellaneous.
In all proceedings before the Consumer Commission, endeavor shall be made by the parties of the council to avoid the use of the CPC.
CPC. Avoid the use of provisions of CPC.
My lord, I will
There are two
DLT
judgments.
Act, I'm sorry, drawing an analogy. DLT Act, under 21H, there's a provision, and 21 or 22, it says it is not bound by CPC.
Correct.
Supreme Court in 1999, Volume 4, SCC 710, ICIs versus LAPCO has said, it means it is not, it's the power of the court are beyond that of civil procedure code.
We are not bound by CPC is
Correct.
one. Avoid the provisions of CPC is another.
I agree, my lord.
See the parliament's intent. You keep the CPC in a capsule.
I
That's
understand,
how
my lord.
it is
My lord,
texted.
what I am trying, why I am trying to say
That we understand. This dispute is as between you.
yes, my lord.
Now the executive said it's in their favor.
Yes, my lord, that will do. All I am saying is, recovery against a firm may be kept open is what I'm saying, my lord, because I don't have an asset today, my lord. And your lordship asked the question, why did you not complete? I used all the money that was received. In the state commission, in the objection, I said, let them pay balance consideration, I'll complete. They did not.
Where is their objection in the state commission? Just give it.
Yes, my lord.
What is the stand you have taken? Let us see.
We don't have. Now,
At least see the Mr. Raghavan. I really tell you.
Yes.
French-like revolution should not happen in this country. And judges, their spouses and children should not be pulled down from the car for manhandling when we go out. To that level, there is dissatisfaction, resentment in the mind of the litigants.
I bow down.
It is horrible.
I bow down, man.
It is horrible.
And
The way our people are very kind people. They have spared our lives.
My lord,
If
that unfortunate situation happens, my lord, all of us are going to be affected and the whole nation will be affected.
No, first they
It is
will.
not individual judges or their family.
With all responsibility, I am saying, people of this country are very kind.
We are very
They are
docile.
kind.
We are very docile.
They are sparing our lives and limbs. What is the longevity of litigations? The other day, Honorable President mentioned about this. See the statistics, startling they are. Where poor people should go. It really, because of your dispute, we can't allow the citizens to suffer like that. And right to have a house is a fundamental right.
Absolutely.
Consistent with that, we have to
My lord, I bow down to what your lordship say. I cannot whisper, my lord, even breathe loudly against what your lordships are saying.
ಈಗ ಅವ್ರಿಗೆ ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಕೊಡಿ ಈಗ
ಮಾಡ್ಕೊಡ್ತೀವಿ. My lord, ನಮ್ dispute ನಾವು ಸಾರ್ಟ್ ಮಾಡ್ಕೊತೀವಿ. These are
Adit, we are sending a panel of our commissioners.
Yes.
A panel of commissioners.
Yes.
You also go. Mr. Aditya will come. One gentle lady who has exposure to construction and such matters. They will be knowing kitchen ಎಲ್ಲಿರ್ಬೇಕು, ದೇವ್ರ ಮನೆ ಎಲ್ಲಿರ್ಬೇಕು ಎಲ್ಲ ಹೆಣ್ಮಕ್ಳಿಗೆ ಗೊತ್ತಾಗ್ತದೆ, ನಮ್ಗೆ ಗೊತ್ತಾಗಲ್ಲ. ನಮ್ಗೆ ನಾವು ಬೇರೆ ಬೇರೆ ನೋಡ್ತಿರ್ತೀವಿ ಆ ರೀತಿ. ಹೇಳಮ್ಮ, ಬರಮ್ಮ ನೀವು ಬನ್ನಿ. Yes, you also go. ಬರ್ಕೊಳ್ಳಿ. The partners of the firm, namely Shri so and so and Shri so and so, are personally present before the court in obedience to order dated Monday date
12th February.
12/2/2025. First off, learned senior advocate Mr. Raghavan appearing for the petition, who apparently is not a party nomine to the proceedings in question before the commission, submits that he is a client on instruction of the advocate on record, submits that his client has brought the draft sale deeds as was directed by the said order in favor of how many people?
50? Yes,
in favor of 55 buyers, stroke subscribers.
Some of whom are
Some of whom are not parties to the proceedings before the tribunal or even before us. First, Mr. Raghavan adds that his client has also made huge investment for completing the construction, which otherwise ought to have been done by the other two partners who are personally present before the court. First off, what is your submission on that? He has finished it.
We had substantially completed the construction, but the delay in construction.
No, not on that. I have constructed.
I have completed.
Sir, he has completed. Part of the construction which was left over, he says he has completed. Ask them whether they dispute or not. Ask them whether they have completed. whether they have completed.
They're saying last 10 to 15% they have completed.
Who?
The petitioners.
Barkal. The said partners on being specifically asked, submit that the petitioner has completed only
Last 10 to 15% of the project work.
10 to 15% of remainder of the construction.
And balance was done by us.
And the rest of the construction was accomplished by themselves. By first.
ನಮ್ ಪ್ರಕಾರ 40% ನಾವು ಮಾಡಿದೀವಿ, ಅವ್ರು 60% ಮಾಡಿದ್ರು ಅಂತ.
Mr. Raghavan submits that the extent of construction done by his client is about 40%. Yes. 40%. First off, who constructed how much cannot be undertaken. Examination of who constructed how much cannot be undertaken by the rate court. Rate court. Therefore, that question has to be addressed elsewhere. Elsewhere. First off. Next paragraph. Now, at this stage, the draft sale deeds having been brought here and clauses, objectionable clauses, ಯಾವ್ದು
ನಾನು ಮೆನ್ಷನ್ ಅವ್ರಿಗೆ ಶೇರ್ ಮಾಡಿ.
May I suggest this, with respect to the sale deed clauses, my learned friend and my learned friend can sit together and work it out. It's a matter of
ಇವತ್ತೇ
ಈಗಲೇ ಮಧ್ಯಾಹ್ನ ಮಾಡ್ಬಿಡ್ತಾರೆ. 2:30 ಬಂದು ಹೇಳ್ತೀವಿ.
There is some issue as to incorporation of certain clauses in the draft sale deeds. Yes. And counsel appearing for the petitioner and the counsel representing the consumers are agreeable to finalize the draft and come out hopefully with consensus afternoon.
A copy maybe
first
given to me also.
A copy of this finalized draft would also be shared with the counsel representing
respondent number 3.
Respondent number 3. 3 annala.
Respondent number 3 now.
Presenting.
Respondent number 2.
Second respondent.
3.
Respondent number 3. We'll say partners representing.
2 is the firm. Partners are petitioner and respondent number 3.
Anyway, you are
Mr. Dheeraj Prabhu and Mr.
representing representing the partnership firm, that is respondents Sri. No, that is our Mr.
Avinash Prabhu and Mr. Dheeraj
Avinash Prabhu and Mr. Dheeraj Prabhu. Full stop. In the next paragraph, in the meanwhile, since there is dispute as to completion of the structures in question, this court with the consensus of all the stakeholders has hereby appoints a commission comprising of learned AGA Mr. Aditya Vikram Bhatt, Mr. Kartikeyan, learned panel counsel of the BBMP Mr. Kartikeyan, and Srimati Savitramma, learned member of High Court Bar, semicolon. The commission is requested to visit, to undertake the spot inspection, and come out with a report. First, the head of the commission, Mr. Aditya Vikram Bhatt, is permitted to take the aid and assistance of any civil engineers for accomplishing the task in question. First, next, it hardly needs to be stated that learned counsel appearing for the parties and the parties, if so interested, may also accompany the commission. First of all, police station Which police station? it comes?
Yelahanka.
police ಅವ್ರು ಬೇಡ.
No, we do not know.
ಇಲ್ಲ ನಾನು my learned friend
ಇಲ್ಲ,
ಇದೆ.
we have done it
ಬೇಡ.
in the past.
ಬೇಡ
ಏನು
ಬೇಡ
ತೊಂದ್ರೆ ಇಲ್ಲ.
ಪೊಲೀಸ್ ಅವ್ರು involve
All right.
ಬೇಡ
They've come always.
ಬೇಡ 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 ಈಗ ಇದು ಅಟ್ಮಾಸ್ಫಿಯರ್ ಅವ್ರು ಪೊಲೀಸ್
Home buyers are never
ಅದು
stopped.
ಕಾಕಿ ಬಟ್ಟೆ ನೋಡಿದ್ರೆ ಸ್ವಲ್ಪ
ಅಲ್ಲ ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಇವರಿಗೆ ಕನ್ಸ್ಯೂಮರ್ಸ್ಗೆಲ್ಲ ಹರಾಸ್ಮೆಂಟ್
ಇಲ್ಲ
Our experience is bit different.
ಐ ನೋ ಮೈ ಲಾರ್ಡ್ ಐ ನೋ
Correct.
But
But
still-
anyway, since you are assuring, ಬರ್ಕೊಳ್ಳಿ. If anybody indulges in any untoward incident or derogatory to the performance of the commission, he is likely to be arrested.
ಇಟ್ ವಿಲ್ ಬಿ ವ್ಯೂಡ್ ಸೀರಿಯಸ್
Arrested. No, we'll arrest always. We want to arrest. Yes. Otherwise ಕೆಲಸ ಆಗಲ್ಲ. ಇನ್ನು ಹಿಂದಿನ ಸೌಜನ್ಯ ಎಲ್ಲ ಉಳ್ದಿಲ್ಲ ಈಗ ಒಳಗ್ ಹಾಕು ಕೆಲಸ ಮಾಡು ಹಿಂಗ ಸಾರಿ ಅರೆಸ್ಟೆಡ್ ಬರ್ಕಟ್ಟು ಎ ಕಾರ್ಬನ್ ಕಾಪಿ ಆಫ್ ದಿ ಸಾರ್ಟ್ ಅಲ್ಲೇ ಅವರಿಗೆ ನೋಡಿ ಅವ್ರಿಗೆ ಎಲ್ಲರಿಗೂ ಒಂದೊಂದು 20,000-25,000 ಫೀ ಕೊಡಕ್ ಹೇಳ್ಬಿಡ್ರಿ ಎಲ್ಲರಿಗೆ ದಿ ಹೂ ವಿಲ್ ಪೇ ದಟ್
ಟು ಬಿ ಶೇರ್ಡ್ ಈಕ್ವಲಿ ಬೈ
ಅಲ್ಲ ಪಾಪ ಅವ್ರು ಬೇಡ ನಿಮ್ಮ ಇಬ್ಬರು ನಡುವೆ ಮಾಡಿ. ನೀವು payment ಮಾಡಿ.
ನಾವು ಅರ್ಧ ಕೊಡಿ ಅವ್ರು ಅರ್ಧ ಕೊಡಿ
ಹಾ.
ನಾವು ಅರ್ಧ ಕೊಡ್ತೀವಿ ಅವ್ರಿಬ್ರು ಅರ್ಧ ಕೊಡ್ತೀವಿ
ಇಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿ ನಾವು ರಿಲೀಸ್ ಮಾಡ್ತೀವಿ.
ಆಗ್ಬೋದು
ಯಾಕಂದ್ರೆ ನೀವು ಅವ್ರಿಗೆ ಕೊಟ್ಟು ಮತ್ತೆ ಇಂಟ್ರೆಸ್ಟ್ ಕ್ರೆಡಿಟ್ ಆಗಿ ಇದೆಲ್ಲ ಬೇಡ.
ಇಲ್ಲಿ ಮಾಡಿ
Petitioner shall deposit rupees 50,000, 25,000, 25,000 and
Shrikers clients. Mr. Shrikers client will deposit 25,000.
Prabhu brothers shall deposit together 50,000 rupees, 50,000 towards the fees in the registry.
ಅವರಿಬ್ರು ಸೇರಿ ಒಂದೇ ರೆಸ್ಪಾಂಡೆಂಟ್.
Really?
No problem. No, that's not a problem.
One submission. Commission to ascertain whether the project is fit and safe for occupancy. ಅಷ್ಟೇ others.
The commission, yes, they will do that. Now they have heard it, na? They will do that. Avರಿಗೆ a carbon copy of this order to be shared with everybody.
I have one other request. My lord, your lordships may, if not now, at some portion, your lordship may consider this submission. That insofar as the claim of 10,000 rupees damages, etc., which they are claiming. So that today, my lord, when they're discussing, what I am given to understand that that's a major bone of contention. They say, who is going to pay me my 10,000 rupees, which has been ordered by the commission? Now they want to keep it alive so far as my client is concerned. I am saying, no, I will not be liable for that, for sure. They are the ones who are parties, they have to be liable. So, my lord, all that I am telling my learned friend is, insofar as that liability is concerned, we have to be absolved. They can proceed against them.
ಇದು ಮುಗಿಸ್ಕೊಂಡ್ ಬರೋಣ ಮಧ್ಯಾಹ್ನ ನಾಳೆಗೆ ನಾಳೆಗೆ ಹಾಕೊಂಬೋಣ.
ನಾಡಿದ್ದು ಡೇ ಆಫ್ ಟುಮಾರೋ.
Friday.
ಆಗ್ಬೋದು. ಅದ್ರ ಮುಂಚೆ ಎಲ್ಲ we will iron out all the creases, my lord. From my side, my lord.
ಈಗ ಅಟ್ಲೀಸ್ಟ್ ನಮ್ ಮಧ್ಯಾಹ್ನ ನೀವು ಡ್ರಾಫ್ಟ್ ಸೇಲ್ ಡೀಡ್ ನಮ್ ನೋಡಿ ಕೊಡ್ಬೇಕೀಗ. ಸೇಲ್ ಡೀಡ್ ನಲ್ಲಿ Bindra, the conveyance, Bindra's conveyance says, in India, the conveyances are verbose and they have become cause of litigations. ಹಾಗಾಗಿ minimum terms. ಇದು ಮನೆ, ಇವ ತಗೊಳ್ಳೋನು, ಇವ ಮಾರೋನು, ಇದಕ್ಕೆ ಇಷ್ಟು ದುಡ್ಡು, ಇದಕ್ಕೆ ಸ್ಟಾಂಪ್ ಡ್ಯೂಟಿ, ಪೊಸೆಷನ್ ಇಷ್ಟು ಮಾಡಿಕೊಡಿ. ರೆಸ್ಟ್ ಆಫ್ ದ ಥಿಂಗ್ಸ್ section 54
TP Act takes care of it.
look into.
Yes, TP Act takes care of it. Implied terms and conditions of a buyer and a seller. But if your lordship sees those green volumes, my lord, that are there, deeds and conveyances, and the 20 volume ಇದೆ. There will be
Ojers, deeds and conveyance.
and there will be a document running to 50 pages for selling one orange.
That's what. ಅದು ಬೇಡ ಅಂತ. ಪಾಪ ಆರೆಂಜು ಸಿಕ್ಕಿಲ್ಲ ಅವ್ರಿಗೆ.
ಅದು there is only one secret, my lord, that your lordship knows. ಅದು because lawyers there, my lord, charged by folio.
ಎನಿವೆ ಅವ್ರಿಗೆ ನೋಡಿ, ನಿಮ್ಮ ಇವ್ರಿಗೆಲ್ಲ ಹೇಳಿ, ನಿಮ್ಮ ಫ್ರೆಂಡ್ಸಿಗೆ ಯಾರ್ಯಾರು ಇದ್ದಾರೆ ಎಲ್ಲರಿಗೂ ಒಂದು ಜಸ್ಟಿಸ್ ಆಗಿಬಿಡ್ಬೇಕು ಇಲ್ಲಿ. ಓಕೆ, ಎ ಕಾಪಿ ಆಫ್ ದಿಸ್ ಆರ್ಡರ್. ಅಲ್ಲಿ ನಿಮ್ಮಲ್ಲಿ ಏನ್ರ ಸೆಕ್ರೆಟರಿ ಅಸೋಸಿಯೇಷನ್ ಏನ್ರ ಇದೆಯಾ? ಎ ಕಾಪಿ ಆಫ್ ದಿಸ್ ಆರ್ಡರ್ shall be handed to the secretary of the association.
ಯಾರು ಗೊತ್ತಿಲ್ಲ ಅವ್ರ ಲಾಯರ್ ಕೊಟ್ಬಿಡ್ತೀವಿ ಲಾಯರ್ ಕೊಟ್ಬಿಡ್ತೀವಿ ಅವ್ರ
Bearers of the associations are very
It will be given to my learned friend. He will pass it on to whoever.
Allon nodri, a copy of this shall be affixed to the conspicuous entry part of the structure, so that all interested parties, persons can read it.
Yes.
Yes. Don't ಹೋಗಿ affix ಮಾಡಿಬಿಡಿ ಅಲ್ಲಿ. ಅವ್ರಿಗೆ ಬಿಟ್ಬಿಟ್ಟು ಇವತ್ತು ಮಾಡ್ಕೊಳ್ಳಿ ನೀವು ನಿಮ್ಮ ಅನುಕೂಲಕ್ಕೆ. ನಿಮ್ದೇನ್ರ ಇಲ್ಲಿ ರಿಕ್ವೈರ್ಮೆಂಟ್ ಇದ್ರೆ ವಿಲ್ ಡಿಸ್ಪೆನ್ಸ್ ಇಟ್. ಡೋಂಟ್ ವರಿ. ಇವತ್ತೇ ಮಾಡ್ಕೊತಿರ್ತಾನೆ. ಸ್ಪಾಟ್ ಇನ್ಸ್ಪೆಕ್ಷನ್ ಇವತ್ತು ಮಾಡ್ಕೊಳ್ಳಿ. ಇವತ್ತು ಹೋಗ್ಬಿಡಿ. ಇವತ್ತೇ ಹೋಗ್ಬಿಡ್ಲಿ ಅವರು. ಹೋಗ್ಕೊಂಡು ಬರ್ಲಿ. ಮಧ್ಯಾಹ್ನ ಏನ್ರ ಇದೇನೋ ಅಜಯ್? ಇದಾರೆ ಮಾಡ್ಕೊಳ್ಳಿ. ಇವತ್ತು ಹೋಗ್ಬಿಡಿ, ನೀವು ಮಾಡ್ಕೊಂಬನ್ನಿ. ಎಲ್ಲರಿಗೂ ಪುಣ್ಯ ಬರ್ತದೆ. ಅವರಿಗೆ ಒಂದೊಂದು ಅವ್ರನ್ನೆಲ್ಲ ಗೃಹ ಪ್ರವೇಶಕ್ಕೆ ಕರೆದ್ಬಿಡ್ರಿ ನೀವು ಮಾಡುವಾಗ. ಓಕೆ ನಡ್ರಿ. ಅನ್ಯಾಯ ಆಗಿದೆ. ಎಷ್ಟು ವರ್ಷ ಅಂತ ಅನ್ಕೋತೀನಿ.
ನಿಜ. I go down to what is happening in this court with all the sincerity, my lord, at my command. ಇದು ಪುಣ್ಯದ ಕೆಲಸ.
Carbon copy of this order shall be shared with the head of the commission. Okay.
Great.
All. ಅದನ್ನ ಡೆಪಾಸಿಟ್ ಮಾಡಿಸ್ಬಿಡಿ 75,000 rupees.
Yes, it will be done. It will be done.
Order may be released immediately.
Immediate. ನೋಡ್ಕೊಳ್ಳಿ. ಅದನ್ನ ಮಾಡ್ಕೊಂಡ್ ಬಂದ್ಬಿಡಿ. ಸೆಕೆಂಡ್ ಮಾಡಿದ್ದಕ್ಕೆ ಇಲ್ಲೂ ಮಾಡ್ಬೇಕು. Okay.
28 can be next week.
28, The Lordship. 28 next week The Lordship, because he is appointed as the commissioner now. ಅದಕ್ಕೆ. All. ಸೂರ್ಯನಾರಾಯಣ ಏನ್ ಕೇಸ್ ಇತ್ತು?
That search, no incriminating material, which came up for 2 weeks.
Yes. One submission to make. The additions, my lord, basically are made on loose sheets and diary found. My lord, whether additions can be made, my lord, that this honorable court, my lord, in Sunil Kumar Sharma's case, has held loose sheets and slips cannot be used to make, my lord, can be for making additions. That, my lord, is in a review petition. We have filed a review petition, my lord, against the dismissal of SLP in Supreme Court. That will have a bearing, my lord. Now, as on now, my lord, loose slips.
According to me, no, because there are any number of, that's only one of the decisions, other decisions of this honorable court. Basically, my lord. Yes.
Please.
Sir, ಅದು 25,000 DD 25,000 DD ತಗೊಳ್ತಾರೆ. 25,000 DD.
GM ಕಾನ್ ಇಲ್ಲೇ ಬರುತ್ತಾ? GM ಕಾನ್ ಇಲ್ಲೇ ಬರುತ್ತಾ?
Order copy ಇಲ್ಲಿಗೆ ತರಿಸ್ಬಿಡ್ತಾರ? Order copy.
So, judgment refer ಮಾಡಿದ್ರು 142. So High Court has powers.
Require the WP number.
I think there was no order to file.
Your Lordship,
Matter has to be heard again.
can you take up for filing, Your Lordship? Actually, last time when we took time, Your Lordship, week after next, Your Lordship.
Any day.
Oblige, Your Lordship.
ಅದು admit ಆಗಿದೆ.
Request. Additional application. Indeed. Mr. Chinnappa has some difficulty today. Mr. Chinnappa has some difficulty this afternoon. If he can be accommodated by one day for him to respond.
Lord, I'll just start, my lord, today because Lord, not more than half an hour to 45 minutes max. I'll have to take your lordships through.
Would the next Tuesday be all right? Next Tuesday? Tuesday.
Wait. ನಿಮ್ದಲ್ಲ ನಿಮ್ಮ
ನಮ್ದು ಯಾವ್ದು?
ಸರ್ ನಮ್ಗೆ ಡೇಟ್ ನಮಗ್ ಕೊಡ್ತಾ ಇದಾರೆ.
ನಮ್ಗೆ ಕೊಡ್ತಾ ಇದ್ದಾರೆ. ಈ ಕಾಂಗ್ರೆಸ್.
Very
No, this matter will not may take about a day, my lord. Once we start, it may take about a day. Batch of matters. Heavy ಅಂದ್ರೆ 1 ವರ್ಷ ನಾವೆಲ್ಲ ಓದ್ಬೇಕಾಗತ್ತೆ. 60 pages of.
Hear me, then if it.
Yes.
Yes. Tuesday, next Tuesday. 25th.
Please. Oh, yes.
No. That's all.
There's one more matter next to Surya's matter. It's number 28. Mr. Aditya Bhatta says he's going for some commission. Commissioner, ready ಇದ್ದೀವಿ ಇಬ್ರು. ಅದಕ್ಕೆ ಹೋಗ್ತಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರು. Thursday, it will not take much time, ನೋಡಿ. ನಾಡಿದ್ದು.
Next.
Yes.
Before I start, my lord, just wanted to say the last matter, we were just hearing that the court should always put itself in the armchair of the litigants. And I was privileged to see that happening in serial number 20, my lord. No, that's what. Yes. Right. Yes, ma'am. I was just talking to my colleague, what we were hearing or reading we actually got to see it. It was real justice to the, yes.
We are here to decide cases and do justice.
Absolutely. Yes. Look, the present appeal is in challenge to the order passed by the learned company judge that order, your lordship, there's a paper book filed by the bank, my lord.
It's remanded with the direction to dispose of the appeal
Yes, my lord.
expeditiously.
That is, my lord, if I just take your lordships through the sequence,
Ah.
page 37 of the paper book, if your lordship. This is the order which is impugned now, my lord, before your lordship, passed by the learned company judge on applications CA 1035, 4 applications basically, my lord. Page 37 of the paper book is the order dated 3rd of November 1998, my lord,
Oh,
passed by the learned company judge on 4 applications. Your lordship will get the CA company application.
1035,
1036, 481 and 75, my lord.
correct.
Except CA 136, which is filed by the deputy commissioner or divisional commissioner, my lord. Rest 3 of the applications are filed by the bank, my lord.
In a company petition.
In a company petition.
What is that company petition?
Now, company petition, my lord, I'll just take briefly, my lord. Then after this order being passed by the learned single judge, then this was in appeal at page, if your lordship sees page 185, my lord, of the paper book. The bank was basically allowed to go ahead and auction the land in question, my lord. That was
180?
185, my lord, division bench. The previous division bench, my lord, passed this order 6th of September 2007, my lord.
In
Where-
OSA.
Yes, my lord, where the company applications filed by the bank came to be dismissed.
This OSA was against 31198 order.
Yes,
What was that order?
the one which I just, Justice Saldana's order, my lord. I'm just leading as to how again the matter has come back before your lordship.
Yes.
This was the previous order passed by this court, my lord,
Okay.
which in turn was challenged by the bank.
So
At page-
now OSA is before us.
Yes. The order which I just initially pointed out of Justice Saldana's company learned single judge, my lord.
Correct.
That is under challenge before this division bench. The previous order passed, my
Set
lord,
aside
was set aside by the Honorable Supreme Court.
and
at
remanded.
Page 203.
Correct.
By posing few questions, 7 questions, which your lordship will find it. 203 is the judgment, my lord.
You are right.
And 211, lordship may kindly turn to page 211, my lord. Para 18, I'll just read that one para, my lord. Para 18, my lord. The question which would remain is, having set aside the findings which persuaded the division bench to interfere with order passed by the company judge as to what is the nature of grant, whether grant is an alienation in sense of a sale, whether the power of resumption which vested with the respondent state continued, what are the conditions subject to which said power would continue to be available to the grantor, whether the fact that winding up petition had been filed and having regard to the terms of the order of the winding up also, whether it would be open to the appellant to contend that power of resumption has come to an end, whether an auction purchaser of the land in an auction, if conducted by official liquidator, would acquire a right in land which would extricate him from power of grantor to resume the land. We would think that all these questions must now be gone into by division bench as we have interfered with so and so. Now what we have done.
Perhaps there was a grant of land by the government.
Yes, madam.
And that in respect of that grant, question arose whether it is an absolute grant in the sense the title itself has passed to the grantee.
Yes.
With no power of resumption at all.
That's all. That's the point.
That appears to be the core issue.
Yes, absolutely.
In this matter.
Yes.
So learned single judge proceeded on the assumption that it was an absolute grant.
The learned single judge, in my view,
In your favor.
tried to balance the
These
rights of the state as well as the bank.
This land was furnished by you have
This
guarantee.
issue, this list as to who is the owner of the, or in whom the ownership rights continues to exist was not decided by the learned single judge.
1 second.
The approach was more to balance the rights of the state where the learned single judge says that, yes, bank can proceed, but what kind of rights that the auction purchaser would acquire, whether he steps into the shoes of the company so as to be bound by the other conditions that the state had imposed, was also left open, and it said that more or less they would also be bound by the conditions. So really, there has been no adjudication with regard to the title of the property is concerned, my lord. I'll take your lordships through that order in detail, my lord.
Yes.
But may I request you,
Why
lordship,
that land was given by way of guarantee, security for the repayment of loan?
to establish the factory itself? The
No, why bank?
bank loan company to whom the land was granted, my lord, was permitted to mortgage and raise loan of 20 lakhs. And they borrowed some more money, and winding up proceedings was initiated by the bank, my lord, under 433E of the Companies Act. And inability to pay the debts, the company was wound up. That order is also there before your lordship, my lord. And then the findings of the company, in the company petition, winding up the company also will have a bearing insofar as this aspect of the matter is concerned, Lord. I'll point out to those paragraphs where the company judge, while passing up, winding up order, my lord, goes to hold that there is no absolute title in favor of the company.
So that finding is already recorded.
Recorded, it was appealed and has attained finality, my lord. Now, is it open for the learned single company judge to go back upon that finding, my lord, with regard to the
But
question
now
of title?
the apex court framed so many questions. Then that question commits suicide.
That's also for your lordships to consider, my lord. In the light of the previous, nothing has been decided in terms of, all these questions are now left open for your lordships to decide.
Now, if a company court's winding up order decides that issue,
yes,
and appeal against that has failed, the finding has attained finality.
yes,
The doctrine of res judicata operates
yes,
at the successive stages of the same proceeding.
yes, that's our primary contention. That's our primary contention.
But that contention now, whether would avail because of the questions framed by the apex court.
It has to be answered along with those questions also.
No, these questions are framed
Yes,
on the premise that the finding has not attained finality at all.
That question was never put forth by,
Not attained.
no, I'll
not
point
by
out.
Supreme Court.
But generally, if Kiran says.
That is my primary ground.
Ground.
That's my primary ground. We have, all of us have filed. Court officer, ಇದು ಒಂದ್ ಸ್ವಲ್ಪ ಸಿನಾಪ್ಸಿಸ್ ಇತ್ತೆಲ್ಲ ಪಾರ್ಟಿದ್ ಕೊಡ್ತೀರಿ ಫೈಲಲ್ಲಿ ಡೇಟು 20th of September 23.
Let us in a
Yes, my lord.
couple of seconds, just show that finding.
Yes, my lord. Lordship may kindly
Speech.
take the page 24 of the paper book, my lord. '24 is the order dated 19th of October 1987, my lord. Honorable
Senior
Justice-
Bopanna's.
Senior Bopanna's order, my lord. Now, my lord, para 10 and 11 at page 34, my lord. Yes. My lord, para 10, shall I read, my lord?
Yes, however.
However, one contention which requires some consideration by this court is the submission that the outstanding loans due from the company are fully secured by mortgage of immovable properties, measuring about 75 acres and odd as noticed earlier. These lands do not vest in the company, absolutely. This is evident from annexure A1, A2 and A3 filed by the petitioner. These lands were granted by the state government under certain conditions, more particularly mentioned in the order of grant. That is the reason that the company had to take permission of the state government for mortgaging these lands to the petitioner bank, as is evident from annexure A1 filed in the writ petition. Government has imposed certain special conditions for alienation of these lands. Under clause 4, the government may resume the land wholly or in part with any building thereon if in the opinion of the government land is required for public purpose or for conducting mining operations. In the event of such resumption or in the event of acquisition of land for any reason, the compensation payable for the land and trees shall not in any case exceed the amount paid by them by the grantee or their value at the time of resumption or acquisition, whichever may be less. The event of resumption under condition on the land shall, the government shall either purchase them or direct the grantee to remove them. 11. In the light of these provisions in terms of the grant made in favor of the company, the security furnished by it cannot be treated as sufficient security which bank could enforce at a later date. The company having failed to establish that it has an absolute title to the lands in question, it cannot depend on slender security offered by it to avoid an order of winding up but by this court. So therefore, my lord, this finding
That security was not furnished with the consent of the government?
it was furnished with the consent of the government only to the extent of 20 lakhs. And with whatever limited rights, that order is also there. If Lordship may kindly turn to page 21, my lord. 21.
So it was a limited security.
Limited the security, which was made known, my lord.
Otherwise, the question of government granting consent would not have arisen at all. Is your
That was also one of the condition in the grant, my lord. That they must
for
take,
mortgaging.
they must take permission. In accordance, acting on that condition, they wrote to the Deputy Divisional Commissioner saying that we intend to mortgage. We want to establish the factory. And we passed this order at page 21, my lord. That page 21, document number 3, dated 30th of November 1963, my lord. Lordship may kindly see para 3 at page 22, my lord. This is a case, page 22, my lord. This is a case in which a loan is proposed to be raised for purpose of, for which land has been alienated with the establishment of spinning mill at Bellary. The mortgage is stated to be without possession. The loan is proposed to be raised from a bank, Canara Industrial and Banking Syndicates Limited. After a perusal of records, the Deputy Commissioner is satisfied that there is no harm in allowing the mortgage of the land without possession to the said bank. The mortgage being only of whatever limited rights and title spinning company possesses over the land. 4, my lord. Next page. Permission is accorded for mortgage without possession, alienated, so and so. Whatever rights company has over the land under general and special conditions or alienation referred to in the memo cited above. Now, my lord, the bank is fully aware of this letter on basis of which loan is now advanced to the company, my lord. We have clearly stated in this letter that company has only limited right in the land, my lord. Based on this letter, my lord,
No, you said 20 lakhs. Which is that 20 lakhs item?
my lord, at para 2, my lord. Para 2 of the same letter, 20 lakhs. My lord, the land itself was given. Lord, the terms of the grant is also available. Your lordship may kindly see for a moment. The primary contention of the other side is that the grant is for an upset price of 500 rupees per acre, and therefore it amounts to conveying an absolute right. But
No, two things are there. Even when absolute title is conveyed,
yes,
still the grantor may retain certain conditions.
yes,
And they are not hit by section 10,
They are not
11,
hit.
13, 14 of Transfer of Property Act.
yes.
Because it will not be a case of transfer under section 5 of the Transfer of Property Act.
Yes,
A grant of land
yes,
is not a transfer under section 5
yes.
of Transfer of Property Act.
That
There
is
are
the-
such.
yes, the Haji
That Haji ke Kuti Naha.
clearly states that it
Ha.
is outside the purview of the TP Act, my lord.
That's what.
And Government
is.
Grants Act, the government can still impose conditions.
Conditions.
And it will not be or section 10 will not be attracted.
Not be applicable.
Will not be attracted. Now, my lord, largely your lordship will have to document number 1 at page 13 is the grant order, my lord. So the terms of the grant is what basically falls for interpretation, my lord.
Even under the government order, it is so stated
It is stated, my lord.
that
The-
all whatever subject to whatever conditions grant is
Correct.
made,
Correct.
those conditions will govern the mortgage.
Yes.
Yes, it is made absolutely made known to the bank, my lord. They cannot turn around and say today that their mortgage deed is superior. It is subservient to our conditions. Because while granting permission for the company to raise loans,
The case of Nemo debt quod non habet.
yes, their
Any
rights
market.
cannot, yes, in simple terms.
So whatever title, subject to whatever conditions the grantee held,
Yes,
he cannot create a larger one free from those conditions
absolutely.
in favor of the mortgagee.
Yes.
Is your submission.
Whatever rights he had, he can pass, he cannot enlarge those rights.
That's all.
Yes.
In other words, even assuming that it was a complete title, full title.
It was not a complete.
No,
Assuming, yes.
Still, since it is not a transfer under section 5 of the Transfer of Property Act,
Yes.
the conditions under 9, 10, 11, 12, 13, perhaps 14 also, perpetuity, etc.
Yes.
of TP Act would not be applicable
applicable.
because of the decision of Apex Court.
Yes.
Number 1, so that is your contention.
And the company having been wound up, the purpose for which the land itself was given has also come to an end, my lord.
But that is not the condition.
No, condition 1 says it shall be used only for the purpose of establishing the spinning mills, my lord. That's why one of the questions that the Honorable Supreme Court says is, any auction purchaser who steps into the shoes will also be, will be bound by this.
But to the extent of 20 lakhs, otherwise that will be defeated. Where was the reason for you are giving consent?
Correct.
At least to the extent of 20 lakhs, you are bound by.
I'm bound to the extent of that.
To that extent, your conditions, all conditions which you otherwise would have enforced against the grantee, they are silenced.
But I did not give up my right to resume the land on the breach of conditions. Now, my lord, even before.
That is subject to 20 lakh limit.
Now, my lord, in the present case, there is a show cause notice issued even prior to the filing of winding up petition, where I say to the company that you have not complied with the terms of the conditions. Entire extent of land was not utilized. They were in fact.
No, assuming everything is right. But so far as 20
But I have made it known, my lord. I have made it known that it is subject to my conditions.
No, that will defeat the object of giving 20 lakhs. The object of giving this instrument is to secure repayment of at least 20 lakhs. Otherwise, where was the need for giving this one? Amount is specified. You intended, at least you give an impression that to the extent of 20 lakhs. Otherwise, you would have said, no, we will not give consent at all. That is not your stand. Which bank it is?
Syndicate bank.
Syndicate bank subsequently transferred to Canara Bank.
Because as on date of winding up, my lord, the sum due was about 3 crores to the bank. And today the Honorable Supreme Court, they have made a submission that it is 1,500 crores. It has snowballed into 1,500 crores. And I'm not a party to the mortgage deed.
No,
I'm not a borrower.
No,
to
you
that
need not
extent.
be. You need not be. But you vouch the title of the property furnished by way of security. There is one law of mortgages.
Yes.
By, I think it is by Banerjee. It's a Tagore law lecture series.
Yes.
Law of mortgage by Banerjee.
Yes.
Tagore law lecture series.
Yes.
you gave this letter and marked it to the bank also.
Yes, it is basis on this letter itself, bank has.
Bank,
that's-
what the bank had asked, where is the bank's
Lord,
version?
That's why, my lord.
Ah.
Learned single judge also observes in the order, my lord, that the bank should have been careful while lending this amount to the company, my lord.
No, it is
There were, of
careful.
course, other plants and machineries. Now, my lord, the amount was extended to them in 1963, my lord. The winding up petition is filed because there were other money which was extended for which no permission was obtained, my lord. That's also one of the violation of the conditions.
Pardon?
Apart from 20 lakhs, my lord, additional sums were also extended to the company.
No, that.
And
you are
no
not
such
concerned.
permission was taken.
You are confined to 20 lakhs. Arguably, there are many aspects. Again, you are confined to the
Then I would.
object of your letter. This letter has to be construed not as an instrument under the act. It is not a legal instrument. It is other than a legal instrument. Therefore, in interpreting instruments of the kind, the principles that apply for interpretation of documents should apply. The principles apply for construction of documents. The principles apply for construction of statutes. There are principles which are confined to, in their application, to statutory instruments like delegated legislation, this, that, etc. But once you give, therefore we wanted to know where is the letter of the government, well, the bank. What the bank asked you, let us see. This is in reply to bank's letter.
No, this is in reply to the company's permission to the government.
Where is that letter?
That letter I have not.
Of the record, but there's a reference to it at page 21.
We want to read because this is in response to that letter. Therefore, in interpreting this, letter has to be borne in mind. This is triggered by your letter. Your means?
Letter of the company.
Where is that letter? Our letter is.
But I will try to get it. It is not right now, it is available.
It will be with the OL now.
Well,
OL.
I will try to find out, my lord, whether it is available.
ಅಲ್ಲಿ ಅವ್ರು ಏನ್ ಕೇಳಿದ್ರು ನೀವೇನ್ ಹೇಳಿದ್ರಿ?
May I just point out to the condition, my lord, to which Lordship may kindly see condition number.
Page number?
My lord, page 15 are general and special conditions. Before that, my lord, may I just read the order of the grant itself at page 13, my lord.
1.3,
my lord. This is the proceedings of the government of Mysore. Now, my lord, now the question is that the bank is contending that the company has become the absolute owner by virtue of this grant. Now, it is nothing to do with the.
Now, if that were to be so, where was the requirement of sending letter?
That's
the government.
So their contention is that by virtue of this grant order, the company became the absolute owner, and now they are entitled to bring this entire property for the sale and appropriate those proceeds as secured debtor.
There are two more things. It is not a private transfer.
No.
Yes.
It is a grant.
It's a grant.
Arguably, it answers the grant under Government Grants Act 1897, other one act is
1895.
1895, which Karnataka legislature has adopted.
1973.
This happened, but after that.
But even then, the case law says it is declaratory in nature.
That
it is not really an enactment. It's more of a declaratory in nature to say that TP Act is not applicable to any government grant act. And decisions have held, my lord.
Otherwise, also TP Act is not.
It is not a transaction between two private individuals.
Correct. No, even government also. Suppose if the government sells the property, government can, it's a corporate entity. Summoned in jurisprudence says.
Yes.
And there are judgments of the apex court. Government is a corporate entity.
Yes, ma'am.
Therefore, it can sell, provided there is a sale deed.
Sale, there is no sale deed, my lord.
Therefore, it is not a case of transfer as defined under section 5 of the Transfer of Property Act.
Sir.
Transfer of Property Act nalli
Yes.
sale, exchange, gift, mortgage, lease.
Yeah.
These are the 5 traditional modes of transfer.
Transfer of property, section 5, my lord.
5 means
In the following
one
section,
living person.
transfer of
Yeah,
property means an act by which a living person conveys property in present or in future to one or more other living persons
Or to himself.
or to himself
Correct.
and one or more other living persons and to transfer the property. Is to
Means
perform such a
Like that. Either ಆ transfer ಆಗಲ್ಲ. It's not a sale.
That's our contention.
No, it appears to be that way.
Yes.
Where sale takes place without, there is a difference between grant and sale. Sale is defined under section 54 of the Transfer of Property Act.
But this 1872 Act will not apply to this district. There is a government statement of objection reason. It says Act 13 of 73, Government Grants Act 1895 is in force in Belgaum area, Mangalore and Kollegal area and Coorg districts only, according to this Act provision. Because this Act will not apply to Bellary district where there is a specific mention in this.
Which is that notification?
ಅಲ್ಲ ಅದರಲ್ಲಿ ಅಲ್ಲ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಆಬ್ಜೆಕ್ಟ್ಸ್ ಅಂಡ್ ರೀಸನ್ ಅಂತ
Government India Act.
ಅಲ್ಲ ಈ ಕಡೆ ಈ ಪೇಜ್ ಹಿಂದ್ಗಡೆ
Statement of objects and reasons. ಅದರಲ್ಲಿ ನೋಡ್ಬಾರ್ದು ಸೆಕ್ಷನ್ ಅಪ್ಲಿಕೇಶನ್ ನಲ್ಲಿ ಹೋಗ್ಬೇಕು. ಅಬ್ಜೆಕ್ಟ್ಸ್ ನಲ್ಲಿ ಏನ್ ಬೇಕಾದ್ ಬರ್ದಿರ್ತಾರೆ ಅದನ್ನ ಓಟ್ ಆಗಿರಲ್ಲ ಏನಿಲ್ಲ ಪಾರ್ಲಿಮೆಂಟ್.
ಅಲ್ಲ ಆಬ್ಜೆಕ್ಟ್ಸ್ ಅಂಡ್
ನೆಕ್ಸ್ಟ್ ಬನ್ನಿ.
This particular case, my special submission is that there are particular rules for Bellary district, which are enclosed with the paper book.
214
Section ಓದಿ 1973 Act ಓದಿ ಟೈಟಲ್ ಎಕ್ಸ್ಟೆಂಟ್ ಕಮೆನ್ಸ್ಮೆಂಟ್ ಅದ್ ನೋಡಿ. It shall extend to the whole of the state of Karnataka.
Yes.
Objects and reasons, it's not voted in the parliament. Idu law, not that. It is only the government's proposal. It is extended to the whole of state of Karnataka. Now let us see section 54. My knowledge of 54 is also of my college days. Let us see 54, how it reads.
TP Act.
TP Act ಅಲ್ಲಿ ನೋಡ್ಬೇಕು. ಅಲ್ಲಿ ಒಂದು ಆಕ್ಟ್ ಬಡಿ ಇದೆಯಾ? Do you have that?
I have soft copy.
ಇದೆ ನಮ್ಮಲ್ಲಿ. We have a lot of law, though not justice.
Sale defined.
Sale defined.
Sale is a transfer of ownership in exchange
For a price paid.
for a price paid or promised or
Or
part paid.
paid and part promised.
Sale how made.
Sale how made.
Such
Such a
transfer
transfer in the case of tangible immovable property of the value of 100 rupees and so and so other thing can be made only by a registered instrument. In the case of tangible immovable property of the value of so and so transfer will be made either by registered instrument or by delivery of property. That second is not. It can be made only by a registered instrument, even if it is a government. Registration as such is reader section. There is one section which exempts the government from registration. Which is that? Registration Act. There is such a section. Therefore, always I tell all books prescribed for LLB course by National Law School should be read. All books should be read. You can't say I am a criminal lawyer, therefore I need not read civil law. I am a tax lawyer, I need not read Hindu law. A concept nadiyudella. All half-baked lawyers ಆಗಿಬಿಡ್ತಾರೆ. Judges also, less than half-baked judges. There is one section in the Registration Act,
Yes.
which exempts instruments executed by the government from registration.
Yes. Nineteen.
Huh?
19.
19, huh?
990.
90.
Exemption of certain documents executed by or in favor of government. Nothing contained in this act or in the Indian Registration Act or in the Indian Registration Act 1871 or in any act thereby repealed shall be deemed to require or to have at any time the registration of any of the following documents or maps, namely. No. Yes. D. Miller, sanads, inam, title deeds, and other documents purporting to be or to evidence grants or assignments by the government of land or by any interest in land. Section 90. 1D, my lord.
D.
1D.
It is an exemption
From registration.
No, from act. Read the heading.
Yes. Exemption of certain documents.
But the ಮೇಲೆ ಇರುವಂತದ್ದು exemption from act ಅಂತ ಬರೆದ. That is perhaps editor might have printed it. May not be. Exemption of certain documents executed by or in favor of the government.
Yes.
Only 91D.
Yes. Sanads, inam, title deeds and other documents.
Yes.
Purporting to be or to be evidence grants or assignment by government of land or any interest in land or.
Subsection 2 adi. Ali deemed registration ide.
All such documents and maps shall, for purpose of section 48 and 49, deemed to have been and to be registered in accordance with.
The deemed registration clause ide.
Yes.
ಅದು ಏನೋ ಸ್ವಲ್ಪ ಅದು only for the purpose of 48, 49.
48 and 49.
48 says, where a document is compulsorily registrable, if not registered, shall not bring into existence the intended transaction.
But Government Grant Rule, Grants Act 1895, Act 15 of it itself, Section 2, Transfer of Property Act in 19, not to apply to government grants. Nothing in the Transfer of Property Act in 18 contained shall apply or be deemed to have ever to have applied to any grant or other transfer of land or any other interest thereon, therefore made.
TP Act is not applicable.
Yes.
Hangage it goes against you.
Yes.
What is meant by a grant?
Lord, may I pass on one judgment of our High Court?
Whether grant is defined?
It is not defined in the act. That is what the judgment says.
General Clauses Act nallu ilva? Padri, General Clauses Act.
Lordship may kindly see para 16, my lord, of this judgment in Mohsin Ali versus State of MP. This court said, in the widest sense, grant may comprehend everything that is granted or passed from one to another by deed. But commonly, the term is applied to rights created or transferred by Crown, grants of pensions, patents, so and so. 14 may be seen, my lord. It is true that word grant is not defined in Grants Act. Para 14, my lord. But it is quite evident that the word has been used in the act. Para 14, my lord.
General Clauses Act nalli ilva? You should not take even final court's words also as final. We have to look into many aspects. Only law declared is final, ashte.
Yes. There's no mention of grant in general clauses.
You're right. Karnataka General Clause Act, Mysore General Clause Act ಕೊಡಿ. ಪ್ರೈಸ್ ಅಂತ ಅಂದ್ರೆ ಏನು? 54 ನಲ್ಲಿ ಸೆಕ್ಷನ್ 54 ದಲ್ಲಿ ಪ್ರೈಸ್ ಪೇಡ್ ಆರ್ ಪ್ರಾಮಿಸ್ಡ್ ಅಂತ ಇದೆಯಲ್ಲ, ಪ್ರೈಸ್ ಅನ್ನೋದನ್ನ ಹೆಂಗೆ ಡಿಫೈನ್ ಮಾಡಿದ್ದಾರೆ ಕೋರ್ಟ್ಗಳು? ವೆದರ್ an offset price is also a price.
That is presumed to be a sale price actually, that upset price. Not whatever.
ರಿಸರ್ಚ್ ಮಾಡ್ದಂಗ್ ಮಾತಾಡಬಾರ್ದು. ನಾವು ಓದಿಕೊಂಡ್ ಬಂದಿರ್ತೇವೆ ಅನ್ನೋದು ಪ್ರಶ್ನೆ ಕೇಳ್ತೀವಿ.
ಅಲ್ಲ.
Otherwise I have to confront those things to you.
Yes.
Therefore, we are asking a question. Yes. No answer without research.
Look into this.
Look.
Mulla kudi. Mulla on transfer of property, Mitra on transfer of property.
Have some judgments on what is the meaning of upset price. Just place that on.
Price ಮೇಲೆ ಏನಿದೆ? ಅಪ್ಸೆಟ್ ಪ್ರೈಸ್ ಜಸ್ಟಿಸ್ ಚಂದ್ರಶೇಖರಯ್ಯ ಅವ್ರ ಜಜ್ಮೆಂಟ್ ಇದೆ, ಜಸ್ಟಿಸ್ ಚಿನ್ನಪ್ಪ ಅವ್ರ ಜಜ್ಮೆಂಟ್ ಇದೆ. ಅಂದ್ರೆ ಅದು ಲ್ಯಾಂಡ್ ಗ್ರಾಂಟ್ ರೂಲ್ಸ್ ಕೆಳಗಡೆ ಮಾಡಿದಂಥದ್ದು ಅಲ್ವಾ? ಕರ್ನಾಟಕ ಲ್ಯಾಂಡ್ ಗ್ರಾಂಟ್ ರೂಲ್ಸ್ 1966.
One 1991 judgment of this honorable court and one judgment of the honorable Supreme Court.
What is an offset price ಅನ್ಕೊಂಡು? What is a price in section 54? If you want to say that it is a sale, then parameters of 54 would be attractive. The word used by English Parliament is price, which we have adopted. The English Law of Property Act nalli hange ide. Ali Law of Property Act ante. Namda Transfer of Property Act nalli price anta one word ide. What is meant by price? Price, whether it's an English word or it's a legal concept.
Is that
Sale of goods act nallu ide price ಅನ್ನೋ word. How courts have interpreted it? Sales tax act nallu ide price. The income tax act nallu ide transfer of property act. Earlier nalli when the department wanted to buy the property, ಅಲ್ಲಿ word price ittu. How that word is it simply an English word appearing in the dictionary, or in the course of legal history it has obtained the jurisprudential concept? That is how we have to see that.
In the grant order, my lord, what it says is at page 13, my lord, the so-and-so promoter of Bellary Spinning Mills has applied for grant of 75 acres of land, and the Divisional Commissioner Bangalore have recommended the alienation of the land at an upset price of rupees 250 per acre. Page 13 of the paper book. This is the proceedings of the government dated
250 per acre.
250 per acre. Subdivision fee. Upset price of rupees 250 per acre. Subdivision.
ಏನ್ ಮಾಡ್ಯಾರ upset price ಅಂತಂದ್ರೆ ಏನ್ ಹೋಲ್ಡ್ ಮಾಡಿ? Justice Chandrasekhara had said upset price means a price less than the market price ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದ್ರು. ಇಲ್ಲಿ ಏನ್ ಹೋಲ್ಡ್ ಮಾಡ್ಯಾರ ನೀವು ಕೊಡೋ ರೂಲಿಂಗ್ ನಲ್ಲಿ? Just read sentence.
It says that it is
Same
something,
thing.
this is the sale price.
Sale
It is
price.
the minimum sale price.
But dictionary, lexicon.
ಅಲ್ಲಿ ಗ್ಲಾಸರಿ ಆಫ್ ರೆವೆನ್ಯೂ ಟರ್ಮ್ಸ್ ಅಂತ 18 ವಾಲ್ಯೂಮ್ಸ್ ಇದಾವೆ ನಮ್ಮ ಲೈಬ್ರರಿಯಲ್ಲಿ. ಅಪ್ಸೆಟ್ ಪ್ರೈಸ್ ಅಂದ್ರೆ ಏನು ಅಂತ ತಿಳ್ಕೊಂಡ್ಬರ್ಬೇಕು.
Supreme Court says that the term upset price means lowest selling price
Ah.
or reserve price.
Lowest selling price or reserve price. It is not a market price. Low
Of course, it depends on the circumstances.
circumstances. You can't generalize that much. What was the
Literally,
market price when this grant was made in those areas?
I'll ascertain, I had asked that information as to what was the guideline value or
ಆ ಟೈಮ್
market
ಮೇಲೆ
price both.
ಮಾರ್ಕೆಟ್ ಪ್ರೈಸ್ ಏನಿತ್ತು ಅನ್ಕೊಂಡು ನೀವು
Or my lord, then in the preamble, they say 250, my lord.
now one more question.
Yes.
Assuming merely because upset price is paid, will it cease to be a grant, and whether the transaction would graduate to the level of sale under section 54? That question would arise. Number 2, even if it is a sale, since Transfer of Property Act is not applicable,
Yes.
whether government can impose a condition inconsistent with the interest created, section 10 Transfer of Property Act, and section 9, 10 Transfer of Property Act. What is it?
That is answered in our division bench.
Answer?
Answered.
If it's a private sale, then no condition can be imposed inconsistent with the interest created at the section. That 9 or 10 other one, I don't remember.
Section
I'm
10.
just saying it from my memory pond.
10 itself.
10 conditions restraining alienation.
Yes.
Adu restraining alienation adu. Condition inconsistent with the interest created ಅಂತ one section ಇದೆ. 11. Where on a transfer of property, an interest therein is created absolutely in favor of any person, but the terms of the transfer direct that such interest shall be applied or enjoyed by him in a particular manner. He shall be entitled to receive or dispose of the interest as if there were no such direction. Suppose ಒಂದು ಲ್ಯಾಂಡ್ ಅಬ್ಸಲ್ಯೂಟ್ ಸೇಲ್ ಮಾಡಿ ಕೊಡ್ತೇವೆ ನಿಮ್ಗೆ.
Yes.
ಅಲ್ಲಿ ಹೇಳ್ತೇವೆ ನಾವು, ಇಲ್ಲಿ ನೀವು ಇಂಥ ಬಿಲ್ಡಿಂಗ್ ಅನ್ನೇ ಕಟ್ಟಬೇಕು, ಬೇರೆ ಬಿಲ್ಡಿಂಗ್ ಅನ್ನು ಕಟ್ಟಬಾರ್ದು ಅಂತ ಇದ್ದಾಗ, you can ignore that condition because you have become absolute owner of that property and the condition is inconsistent with the interest created, nature of interest created.
Yes.
These are similar provisions you will find in the Indian Succession Act also. Even conditions in a will,
correct,
they are voided by operation of law.
It's precisely
So
for
the question, even when absolute title is granted, still government can create interest.
yes.
Conditions it can impose ಅನ್ನೋದು ನಿಮ್ಮ
Yes,
ವಾದ.
and I'm supported by a decision.
ಅನ್ಕೊಂಡು ಮಾಡ್ತಾರೆ.
It's precisely for this reason, my lord, that a doubt had crept in and Crown Grants Act came to be passed. The object was to ensure that the TP Act does not come in the way and the conditions which the government imposes should not be set at naught by invoking section 10 of the TP Act. It's precisely to overcome. Lord, may I just pass on these two judgments? Sir. No, it will come to 49, no? So this is division bench, not our court.
Under which act it was?
PTCL Act, Lord. The Lordship will also see the questions that fell for consideration.
Section 54 ತೆಗೆದು ಪ್ರೈಸ್ ಅನ್ನುವಂತ ಹೆಡ್ಡಿಂಗ್ ಇದೆ ಅದರಲ್ಲಿ. ಹೆಡ್ಡಿಂಗ್ ತೆಗೆದು
Para 29, if Lordship sees, Lord, the questions which arose for determination
Grant ಅನ್ನೋದಾ?
whether conditions like that a grantee shall not alienate the land forever or a permanent restraint on alienation. That
ಅದ ಲಕ್ಷ್ಮಮ್ಮ ಮ್ಯಾಟ್ರ್.
yes. But Lord,
ಫಾಲೋಸ್ ಇದು ಮಂಚೇಗೌಡ ಫಾಲೋ ಮಾಡೋದನ್ನ ಇದು?
Yes.
Huh?
yeah. But para 49 may be seen, Lord.
49.
A state and its government, irrespective of nature of its polity, can never be equated to an individual or a juristic person. Lands and properties owned by the state or its government cannot be held to be owned by an individual exercising his rights of ownership over the same. The disposal of state property can and must be in conformity with law. On any principle, a government grant cannot be equated to a disposal by a private person in favor of another private person. And then, my lord, lordship will see that notice. No, where is that para?
Price meaning, the word price is used in the ordinary sense as meaning money only. It is used in the same sense as in section 77 of Indian Contract Act. The Supreme Court has held that though price is not defined in the TP Act, it is used in the same sense as in the Sale of Goods Act 1930 and means the money consideration for the sale of goods. The Supreme Court has also held that the presence of a money consideration is an essential element in a transaction of sale. If the consideration is not money, so and so. However, Andhra Pradesh High Court has had a family settlement to be so and so. Price of the estate. Price is fixed by the contract antecedent to the conveyance. Price is of the essence of a contract of sale. Unless the price is fixed, there is no enforceable contract because of no price is or to imply. As in the case of sale of contract to buy or sell. If no price is paid or for, even a registered deed does not effect a sale. However, it is sufficient if the contract specifies the means of ascertaining the law is stated by Fry on Spencer's performance, specific performance as a all sales it is evident, price is an essential ingredient. And where it is neither ascertained nor rendered ascertainable, contract is void for incapable of search. Contract sale, 3 years purchase of the net income is clear purchase. So at least difference is maintained between price and upset price.
So not a market price. But here, my lord, if lordship kindly sees, apart from the upset price, the grant further referred to a divisional fee and a annual ground rent. That is of importance here. That they were liable to pay, the company was liable to pay annual ground rent at the rate of rupees 6.25 rupees per acre.
Oh.
Subject to general and special conditions to be imposed. So, page 14 of the paper book. So it is just, does not stop at upset price, my lord. It says annual ground rent of rupees 6.25 per acre, which according to us was not paid by them at all. And annual ground rent is defined in law lexicon.
Rent payable for the earth, piece of earth.
Yes.
Annually.
In the building.
Building.
And lordship will see.
So it only created anything short of absolute sale anta nee helodu. Whether you call it lease or not, it may partake the character of lease. Upset price being premium.
Yes.
And annual payment being the rent.
Rent.
Because lease is defined under the Transfer of Property Act as transfer of right to possession and right to enjoyment of an immovable property for a premium on the condition of paying periodic rent.
Yes,
So this upset price may partake the character of premium also. You will,
premium. And they were liable to pay.
Read the definition of lease.
Lease 105.
Yes.
A lease of immovable property is a transfer of a right to enjoy such property made for a certain time, express or implied, or in perpetuity, in consideration of a price paid or promised, or of money, a share of crops, service, or any other thing of value to be rendered periodically or on specified occasions to the transferor by the transferee, who accepts the transfer on such terms. Lessor, lessee, premium and rent defined. The transferor is called the lessor, transferee is called the lessee, the price is called the premium, and the money, share, service or other thing to be so rendered is called the rent.
So premium is different, rent is different.
Yes.
Premium is consideration for transfer.
Yes.
And since he goes on enjoying it, as long as he enjoys, he pays the rent periodically.
Yes.
So this amount is in the nature of premium.
Yes.
Just I'm thinking,
Yes.
we are
Yes.
just thinking,
Yes.
we do not
Yes.
know. Don't be under impression that we are saying so many things against you.
Yes.
When it comes to you, many questions will be asked to them also. Okay. Suppose if there is annual rent, how can you say that it is a sale or leave sale? There is even otherwise, there is transfer of absolute title. If you are the owner, to whom you will pay the rent? An owner paying rent is like a person putting his money from taking money from the left pocket and putting it into right, or in the pocket of the pant, if not in the purse.
Yes.
Ownership, Samand says, Samand has dedicated one whole chapter on that. Ownership, according to Samand and according to Julius Stone, it is a bundle of rights. Right to possess, right to enjoy, right to decide mode of enjoyment, right to alienate, fully or partly, right to destroy. These are 5 very, very essential rights in the basket of rights. The ownership is a basket of rights. Where title is absolutely transferred, it fits into any one of these 3: sale, exchange, gift. Absolute title passes on. Where you create interest in the property for securing the repayment of the debt, then it will be one of the modes of mortgages. Simple mortgage, equitable mortgage, English mortgage, usufructuary mortgage, anomalous mortgage, or mortgage by conditional sale. Where there is no debt, there is no sale, gift or exchange, nor mortgage, then interest created in the property for the purpose of enjoyment for a particular period. And he read perpetuity also, lease in perpetuity.
Lease in perpetuity.
On a premium and subject to the condition of paying periodic rent, then it partakes the character of a lease. Here upset price is paid. It's arguable that upset price is, it may fit into the definition of premium, but your answer would be, since Transfer of Property Act would not be applicable, they can't say for one purpose it is applicable, for another purpose it is not applicable. Can there be lease outside section 105? That you have to answer. There can be lease divorce section 105. Then the question will be, because there is one judgment which says the Transfer of Property Act is an extension of Contract Act. And Contract Act says an act to consolidate a part of the law relating to contract. Therefore, the Transfer of Property Act is also a part of the law relating to transfer of property in the Transfer of property is an extension of Contract Act. Contract Act object says the law, part of law being legislated. If you say that Transfer of Property Act is not applicable, then what kind of transaction it is? Number one, whether except these 5 conventional transfers, is there any other transfer? 5 conventional, the sale, exchange, gift, lease, mortgage. Other than these 5, yes, then grant can be. So these aspects will arise. Number one, why all this jurisprudential discussion? Decide that questions which the apex court has raised and leave the case can also be the answer. Because apex court has framed the questions. Questions. So you decide that case by answering these questions. Will also be the simple thing to go. But I have put the things in a larger canvas.
No, we'll do this.
Because there are many youngsters.
We would like to.
Seekers.
We'll go through all of this.
Now New government cannot be on par with an individual at all because of 83. That Lakshmamma.
Yes.
Lakshmamma went to Supreme Court.
Yes.
It went to Supreme Court. Kiran?
Lord, I'll just
see that.
Yes.
I believe it went to Supreme Court. At least Manche Gowda went to Supreme Court.
PTCL.
PTCL.
Lord, one other para if I can read, my lord, which may partly answer para 60, my lord, of the Lakshmamma's case.
49 and 50 you have read now?
Yes, my lord. Para 60, my lord. The first argument had reference to the Crown Grants Act 1895. It was not in its true sense so much an argument as an answer by way of anticipation. The learned wakil for the plaintiffs assumed that for the defendant, Crown Grants Act will be referred to and relied upon as enabling or justifying the alienation and began by assailing it in limine. But looking at the preamble and considering the purpose of the act, it cannot be doubted that the act was rather declaratory in its nature than enabling or enacting. It had to be enacted, so says the preamble, because doubts had arisen as to the extent and operation of the TP Act of 1882. Prior to the Transfer of Property Act, there was no statutory enactment of Indian legislature regulating transfers of property. But after that act was passed, apparently doubts came to be expressed or entertained whether that was an act governing transfer of property by act of parties who were subjects of crown, or whether provisions of the act applied also to transfer of property by the crown. Taking the terms of the Crown Grants Act, the inference seems to be irresistible that prior to the TP Act, there was no doubt whatever.
Why they are referring to Crown Grants Act?
Well, the Crown became subsequently substituted as Government Grants Act, 1950.
Is it?
It's one and the same. The substitution is by in 1950, my lord. Crown, instead of Crown, it came to be now as Government Grants Act. But in essence, it's one and the same. But here, But, the personal law of Hindus or Mohammedans or other communities in India could not possibly affect rights of Christian sovereign power. All acts of legislature owe their origin to sovereign power, whatever that may be in absence of clear indication to the contrary. The provisions of the statutory law should be regarded as governing transactions only of the subjects of sovereign power and not of the sovereign power itself.
Where are you reading?
Para 60, my lord.
60.
But last few lines, my lord. If all acts of legislature, got it?
Yes.
If all acts of legislature owe their origin to
the
sovereign power, whatever that may be in absence of clear indication to the contrary, the provisions of the statutory law should be regarded as governing transactions only of the subjects of the sovereign power and not of the sovereign power itself. Further, the rules of law, whether statutory or otherwise, governing and regulating transfer of property as between subject and subject of the sovereign power are based and should be deemed to be based on principles which cannot in any wise be regarded as applicable to a transfer by sovereign power itself. So even under Article 298 of the Constitution, it can be treated as a contract between the state.
299.
State 298, my lord.
98 or 99?
298 all.
300 is taught.
Yes, 290.
Two
299 is protection to the contracts of the state by the
power
officer.
to carry on trade, etc.
Yes.
298 is power to carry on trade,
Executive, yes, madam. Disposal of property and making of contracts for any purpose. So in executive power of the state, my lord.
But 298 and 299
yes,
are to be read together. If you go to 299, then format is a must.
And in the name of the governor.
That's what, format is a must. That is not your case.
That's not,
no, your case also.
Yes.
Because
the format,
document
yes.
is not the format.
Yes. We off late.
It only shows power.
Yes.
It can carry on trade, business, etc., etc., which will include transferring of property also.
Some of the cases now, my lord, even in arbitration cases, we have argued where one of the clause, while in the e-portal, the clause was that arbitration clause is not applicable. But the officer, while signing the contract with the contractor, does not delete that clause and makes the arbitration applicable. So that is the protection under 299 that the state has.
Where it can say we don't abide by that.
Correct. But even in exercise of 298, my lord, the state has power to enter into.
That's true. Jalan Trading Company versus so and so, Barkoli judgment, which Shirvai has dedicated whole chapter on that. Jalan Trading Company. What state can do, what individual can do, state also can do. And for doing it specially, no legislation is necessary. It can do it under executive the state.
So here, my lord, in this case, since none of us, they are also relying upon Bellary grant rules, which does not permit grant of lands to a company at all. There is no such provision where the
Bellary grant rules were promulgated under which law?
This 19 rules of 1960, my lord, but they were governed.
No, they were promulgated.
Madras area and Bellary district rules of 1960, my lord.
Under which act?
Act was.
Because Bellary was part of Madras presidency.
Yes, my lord. There's a decision, my lord, to that effect, which explains. I'll point out, Lord, which has discussed on this aspect. So nobody has been able to now, my lord, pinpoint under which act this grant has been made, my lord. But it can be construed as.
This was made in the year which year?
63, my lord.
By that time, whether government, the grant rules came into force when? It cannot be, because the grant rules came after 64. Because the Land Revenue Act itself was enacted in 1964. It was enacted in 1964.
Yes. 64
Huh?
replaced by 69 land grant.
ಅದು ಲ್ಯಾಂಡ್ ಗ್ರಾಂಟ್ ಅದು ಬಾಂಬೆ ಲ್ಯಾಂಡ್ ರೆವಿನ್ಯೂ ಕೋಡ್. Mysore Land Revenue Code. There was Mysore Land Revenue Code, but will not be applicable to Bellary.
It says
Bellary was part of Madras.
Madras, my lord.
it extends to the whole of state of Karnataka except Bellary district entire.
ಯಾವುದು?
Mysore Land Revenue Code.
Correct.
Indeed.
Because Mysore Land, Bellary was part of
Part of Tamil Nadu.
Madras province.
Madras.
But then is it not deleted? Karnataka Land Revenue, which is the act you
Delete
have
ಆಗಿದೆ
written?
ಅಂತ ಗೊತ್ತಿಲ್ಲ.
Sir is pointing out in Mysore Land Revenue Code.
Mysore Land Revenue Code will not be applicable. Mysore is up to Tungabhadra.
Lordships may kindly take page 214 of the paper book. We are relying on this, the land grant, Madras area and Bellary district rules 1960.
1960.
1960, the grant is of the year 1963.
So these
Land
rules
grant
were there.
Came in 1968 and then thereafter in 69.
Those, do you have copy of the rules?
It is part of the paper
Part of the
book.
paper book.
Yes.
Let us see how they are structured.
Okay.
Page
ಎಲ್ಲ Supreme Court discussion ಆಗಿಲ್ಲ ಏನಿಲ್ಲ.
In fact, the Supreme Court leaves this question to your lordship, for your lordships to answer, which is the law that applies.
Page number?
Page 214, the paper book. Your lordships may now kindly take rule 3 at 215. It begins at 214.
To whom land can be granted?
Ordinary grants, sir, rule 7 may be seen, my lord.
Can we just point out rule 3 subclause 4 first?
Three.
Rule 3, your lordships may kindly see.
Correct. Power of different revenue officers in the, that is power to grant.
Indeed.
To
Rule
whom
1,
it can be granted?
your lordships will now kindly take rule 3 subclause 4. It doesn't specify as to whom.
No, no,
Why?
it's there.
In the dictionary clause it is there now.
Rule 7 itself.
So far as those grants are concerned, yes. Kindly just take rule 3 subclause 4.
Allah, come to 7.
7, very.
Who is poor?
Individual in.
Who has attained majority is either a bona fide agriculturist cultivating land personally or bona fide intends to cultivate the land personally. Notwithstanding anything, any individual holding land may be granted for an upset price, land nearer to the land so held, if such nearby land is in the opinion of the authority granting the land acquired for the better enjoyment or better cultivation of land. The respect on granted on the signs as a rule and shall be granted on payment of occupancy price or free of cost to poor and landless and to certain categories of persons and institutions. Agriculturist cultivating land, political sufferer, granted purpose of this rule, so and so, so and so. Industrial purpose ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
ಇಲ್ಲ ಇಲ್ಲ. ಇಲ್ಲ ಮೇಡಮ್.
ಎಜುಕೇಶನಲ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಇದೆ.
ಇಂಡಸ್ಟ್ರಿಯಲ್ ಪರ್ಪಸ್ ಇಲ್ಲ.
ಮತ್ತೆ ಕೊಟ್ಟಿರಲ್ಲ ನೀವು.
ಅಲ್ಲ, it's not our case
ನೀವು
that,
ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ.
Lord, it's not our case that land has been granted under these rules. They are now trying to bring it within. The
Under
bank is trying to rely upon.
All right, under which rule you have granted this land?
Well, I would rely upon 298. Executive power of the state to enter into a contract. Because none of us have been able to
No,
point out.
executive power is excluded when law is in operation.
Yes.
It becomes an occupied field,
Coextensive.
coextensive in the absence of law.
So there is no,
And these are the rules.
Yeah.
which does not provide for grant to an
No,
company as such.
that's all right.
There's a
No, see,
prohibition.
policy, not that way. These rules
Yes,
occupy the field of grant. It's the law.
yes,
It provides for a grant of land to A, B, C, D
yes,
on X, Y, Z conditions
yes,
for alpha, beta, gamma prices.
yes.
That's the law. If law is there, you can't exercise executive power. That is Ram Javaya versus State of Punjab. Only in the, and Kharak Singh versus State of MP.
Yes.
Bijo Emmanuel versus State of Kerala. They decided these matters. If law is occupying the field, no question of executive power at all.
It has to be in conformity with.
With the rules only.
But when there are no specific rules for grant of land to industry, then that lacuna or gap can be filled by executive.
No, not lacuna it is. It's not lacuna.
Not like.
Otherwise, everywhere you can do that. That is the argument. Everywhere this argument will be available. Just look into.
I stand correct.
what
I'll
should
look
happen
into
way.
that.
No, no, it's only discussion.
Two provisions in this. Your Lordship may kindly take rule 3 subclause 4. That is at page 217.
217.
217. So rule 3 subclause 1 to 3 pertains to up to 10 acres of land.
To whom? This is
There's a
power of the granting authority.
But there's also rule 16. Rule 3 subclause 4 says no grant of land shall be made by DC in any other case other than those specified above or in excess of the extent prescribed above, except with the previous sanction of the government. Now, in this case, it is the government order itself which has granted the land. In the present case, now kindly take rule 16, Your Lordship, at page 225. That is the power of the government.
225.
225.
No, what AG is saying is, there is no
But there is the power to
power
relax.
to grant is there, extent of grant is specified, prices are earmarked, and the persons to whom the grant can be made are specified. In that list, you do not fall anta. Avagu idna apply ಮಾಡ್ತೀರಾ? Is his question.
ಅಲ್ಲ
I
ಅದಕ್ಕೆ
am relying on rule 16 to just point out to show that the government has the power to relax also. If your Lordships may kindly take rule 16 and 225.
Power of government to relax. How?
Notwithstanding anything
Suo
contained
motu.
in the preceding rule, government may suo motu or on the recommendation of divisional commissioner or deputy commissioner, if it is of the opinion that in the circumstances of any case or classes of cases it is just and reasonable to relax any of the foregoing provisions of these rules. It may by order direct such relaxation subject to such conditions as may be specified.
Where is the order? Relaxing.
My respectful submission would be that the government order itself of
There's a-
1963, that itself is the order relaxing.
In
the
other
conditions.
words,
Yes.
where government grants,
Indeed.
this relaxation question will not arise anta helbodu. This arises where other than government is granting the land. Who granted this land?
The government itself.
Government itself. Therefore, this,
It says the government may suo motu.
So
no, where is the power to the government to grant land?
That my respectful submission would be traceable to rule 3 subclause 4.
3 subclause.
Which your Lordships already saw at page 217. In fact, a similar provision fell for consideration before this honorable court. Of course, that was under the Mysore Land Revenue Code.
Ruler?
Page 217.
217. Subclause right on top of the page. Subclause 4.
4, no grant of land shall be made by the deputy commissioner or other officer in any case other than those specified above or in excess of extent prescribed above, except with the previous sanction of the government. No. Subsect rule 4 speaks of deputy commissioner granting the land or some other authority granting the land. But if you want to grant in excess of that, the previous permission of the government is necessary. That does not empower the government to make the grant itself. Power of the government to grant. That question also now may not, it may be academic because it is already granted before I was born. Many of you were born.
Letter DC.
62.
63, January 63.
Yes, yes. Nobody, none of us was born.
ಅಲ್ಲ ಇದರಲ್ಲಿ in the order itself, government order.
Let me just point out, similar provision was there under the land revenue code as well. They just place that.
Where court said the government has power in that.
Fell for consideration before the division bench of the South. I'll just point out the rule first.
Orchid hotels versus so and so Tagiri. Orchid hotels versus so and so, where conversion was granted by the government itself. The court said it is permissible to the government, something like that. Orchid hotel anta anodena.
This under the rules of revenue code, kindly see rule 32 subclause 4.
Same text.
Same text. That provision
is interpreted. Padi.
May I just please.
Holding that government can grant.
It can grant anta. What had happened was in this case, it was granted for a dairy farm. And the lordships may.
Granted under which provision?
Under this.
Rules only.
Under these rules. Your lordships may kindly take page 322 of this decision.
These rules were made when? Mysore Land Revenue Code.
1888.
1888.
The lordships may kindly take page 322 at the bottom of 322, the last line, but sub rule 4 of rule 42 says, your lordships find that.
322 the law?
Last line. But sub rule 4
of rule 42 says
that provision is
that provision is extracted.
Kindly,
Rule 43 lays down the procedure for disposal of lands for cultivation.
Indeed, for cultivation. Kindly take page 3 to 5 on the last page. The second para.
Same can be in substance, if not in form, be said to have been made under Rule 42(4). The Deputy Commissioner recommended that grant and the government accepted that recommendation. Hence, in our opinion, the requirements of Rule 42(4) were in substance complied with.
Indeed. So my respectful submission would be that relying on this judgment, possibly the government has issued this grant under the 1960 rules. And in fact, the 1960 rules itself prescribe resumption. There's a provision regarding cancellation as well. That is Rule 213.
Correct.
And that is very restricted, Your Lordship.
No, that is, but it
course,
does
the
not prohibit the adding of conditions. The division bench said, in the absence of conditions, these conditions will apply. In addition to these conditions, the government can super add conditions of grant anta hold madar. Adnu nodikoli. All. No, similar provision is there in that. All right, I got the point. I have understood, we have, at least to some extent, we have understood the case.
We'll carry out this research also.
That's why. ಇವತ್ತು ನಾಳೆ ಮಧ್ಯಾಹ್ನ ಇಟ್ಕೊಳ್ಳೋಣ. ನಾಳೆ ಮಧ್ಯಾಹ್ನ ಏನ್ ಬಾಳ ಇದೇನು? ನಾಡಿದ್ದ?
Friday ಬೇಡ. Friday ಬೇಡ. ಇಲ್ಲ, Friday. ಅಲ್ಲ. ಇಲ್ಲ, Tuesday.
Monday or Tuesday.
ಟ್ಯೂಸ್ಡೇಗೆ ಹೋಗಿದ್ದು. ನಾಡ್ದು ಫ್ರೈಡೆ?
ಮಲ,
Friday ಮಧ್ಯಾಹ್ನ
ಮಲ, except Friday ಮಲ.
ಇಲ್ಲ. ಬೆಳಗ್ಗೆ ಇಟ್ಕೊಂಬೋಣ ಫ್ರೈಡೆ.
Friday ಮಲಡ.
ಏನ್ ನೀವು ಒಯ್ಯಲ್ ನೀವು?
ಹೌದು.
ನಿಮ್ಗೆ ಏನ್ ಕಳ್ಕೊಳ್ಳೋದು?
ಅಲ್ಲ, I am the owner of the property as far as I am concerned, but that I have to say that, my lord, I have permitted the bank to mortgage the property and give the loan. To that extent, my lord, I may have to say something. I'm sorry, my lord, Friday I am out of station for some my throat.
ಯಾವ್ದು ಬಂದು ಬೇರೆ ದಿವಸ? ಮಂಡೇ.
Mondays.
All right.
Monday we request for-
ಮಂಡೇ ನಿಮಗೆ
Monday, I'm in,
pressure ಜಾಸ್ತಿ ಆಗುತ್ತೆ.
I'm in Chennai outstation, man.
Okay.
Any other day, my lord, your lordship.
6th. 6th or 7th.
ನಾಳೆನೂ ರೆಡಿ. ನಾಳೆ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಹೇಳಿದಾವ. ನಾಳೆ ಆಗಲ್ಲ ಬಿಡಿ.
ನಾಳೆ Mr. Chinnappa has some difficulty.
ಅಲ್ಲ, ಫ್ರೈಡೆ ನಿಮ್ಮ
Indeed,
ಅವ್ರಿಗೆ ಏನೋ ತೊಂದರೆ ಇದೆ. ನಮಗೊಂದು ಸೋಲಮನ್ ಗ್ರ್ಯಾಂಡೆ ಅನ್ಕೊಂಡು ಒಂದು ಪೋಯಮ್ ಇತ್ತು.
Friday.
ಸೋಲಮನ್ ಗ್ರ್ಯಾಂಡೆ ಅನ್ಕೊಂಡು ಒಂದು ಪೋಯಮ್ ಇತ್ತು ನಮ್ಗೆ 6ನೇ ಕ್ಲಾಸಿಗೆ. ಸೋಲಮನ್ ಗ್ರ್ಯಾಂಡೆ ಬಾರ್ನ್ ಆನ್ ಮಂಡೇ ಸ್ಟಾರ್ಟ್.
Friday, anyway, banks, OL's interest is also protected by the bank.
ಅಲ್ಲ, ಬಟ್
Only if he sir permits, then he, other day for.
Well, I have some my
Health issue.
appointment with my throat infection for every month, my lord.
All.
Friday, my lord, I'm out of station.
ಟ್ಯೂಸ್ಡೇ ವೆನಸ್ಡೇ ಹಾಕ್ಬೋದಾ? ಮಹಾಶಿವರಾತ್ರಿ.
ಇಲ್ಲ, ನೀವು ಮಾಡಂಗಿದ್ರೆ ಮಾಡಿ.
Wednesday ರಜಾ sir.
Huh?
Wednesday ರಜಾ.
27, 28 ನೀವು ಇಲ್ಲ. 27th ಹಾಕೋಬೋದಾ? ಯಾವತ್ತಾಗತ್ತೆ? ಥರ್ಸ್ಡೇ.
Just
27th ಹಾಕೋಬೋದಾ? 27th.
ಅಲ್ಲ, 27th.
ಹಾ.
ಅಲ್ಲ, ಭಾಳ ಸರ್.
ಇಲ್ಲಪ್ಪ, ಬೇರೆ ಬೆಂಚಿಗೆ ಹೋಗ್ತದೆ. ಹೋಗ್ಲಿ ಬಿಡ್ರಿ ಅಂತಾರ ಅವ್ರು. ಪೀಪಲ್ ಪ್ರಶ್ನೆ ಕೇಳೋ ಬದ್ಲಿ 2 ಕ್ವಶನ್ ಬೆಂಚ್.
Even earlier date, my lord, we have known. Even earlier date, my lord, possibly if there is.
Friday.
ಅಲ್ಲ, ನಮ್ಮದೆಲ್ಲ ಬೇರೆ ಬೇರೆ
My lord,
Saturday ಎಲ್ಲ ಇದಾವೆ.
Friday, my lord, I don't mind, my lord, my learned senior counsel arguing, but as far as I am concerned, my lord, I may be given one day, my lord, later.
ಮತ್ತೆ ಟೈಮ್ ಕೊಡಲ್ಲ, ಆ ರೀತಿ ಕೊಡಲ್ಲ. ನಾವು ಹಿಂಗ್ ಇದ್ ಮಾಡ್ಲಿಕ್ಕೆ ಇಷ್ಟ, ಯಾಕಂದ್ರೆ ಇಷ್ಟೊತ್ತಿಗೆ ಮುಗಿಸ್ಬಿಡ್ತಿದ್ವಿ ನಾವೀಗ ರಿಸರ್ವ್ ಮಾಡಿ.
Monday.
Lord, Friday,
He said 1 day.
One day, man.
one day for the,
Malad,
sir to come and.
Malad, if he is arguing, my learned senior counsel is arguing, my lord, I may have given one day, my lord, for some half an hour.
ಆ ರೀತಿ
Half an
ಕೊಡಲ್ಲ.
hour or 45
ನಮ್ಗೆ ಆ ರೀತಿ
minutes.
ಅಷ್ಟ್ ಟೈಮ್ ಇಷ್ಟ ಟೈಮ್ ಕಳೆದಿದ್ದೆ ಅಲ್ಲ ಇದು. ಇದರಲ್ಲಿ ಒಂದು ಏನೋ ಒಂದು ಇಂಪಾರ್ಟೆಂಟ್ ಇಶ್ಯೂ ಕಾಣ್ತಾ ಇದೆ. ಯಾಕಂದ್ರೆ ನಾವು ಒಂದು ಏನು ಲಾ ಲೇ ಡೌನ್ ಮಾಡಿದ್ರೆ ಮುಂದೆ ರಿಪರ್ಕಷನ್ಸ್ ಎಲ್ಲ ಏನೇನಿದೆ ಅನ್ನೋದಕ್ಕೆ ಇಷ್ಟು ಹಿಯರಿಂಗ್ ಮಾಡ್ಬೇಕಾಗ್ತದೆ. ಜಸ್ಟ್ ವಿ ಹ್ಯಾಡ್ ಪುಟ್ ದ ಥಿಂಗ್ಸ್, ಇಷ್ಟೆಲ್ಲ ಆಸ್ಪೆಕ್ಟ್ಸ್ ಇದೆ ನೋಡಿ ಅಂತ ಹೇಗೆ ಅಂತ. ಇದು ಯಾವುದನ್ನು ಹೇಳ್ದಂಗೆ ಆಗ್ಬಿಡ್ಬೋದು, ಯಾಕಂದ್ರೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಕ್ವಶನ್ಸ್ ರೇಸ್ ಮಾಡಿಬಿಟ್ಟಿದೆ. ಬಟ್ ಒಂದ್ 2 ಕ್ವಶನ್ ನಾವು ಡಿಸ್ಕಷನ್ ಅಲ್ಲಿ ಬರುತ್ತೆ. 2 questions fit into our discussion.
25th, my lord.
25th?
ಹಾ.
ಹಾಕ್ರಿ. 25th ಯಾವತ್ತಾಗ್ತದೆ? ಟ್ಯೂಸ್ಡೇ ಮತ್ತೆ ಯಾವ ಮೇರೆ ಅಂತ ಹೇಳಿದ್ರೆ ಯಾವುದು?
We'll take our chance.
25th morning, sir.
No, anything.
Afternoon, he has again.
Morning.
Arbitration. ಬಸವರಾಜ್ ಮತ್ತು KG ರಾಘವನ್ ಅವರು ಟೈಮ್ ಇದು ಮಾಡ್ತಾರೆ ಅವರು. They will take more time to argue. ಟ್ಯೂಸ್ಡೇ ಆಗಲ್ಲ. 27th ಇರ್ಲಿ.
27th.
27
morning.
ನೋಡ್ ಹೆಂಗಿರ್ತದೆ ಅನ್ನೋದ್ರ ಮೇಲೆ ಡಿಪೆಂಡ್. ಓಕೆ, ಜಾಸ್ತಿ ಹಾಕ್ಬೇಡ. ಇನ್ನೂ 2 ಇದೆಯಾ? ಕೊಡಿ. All right, thank you for so much discussion, for engaging us in so much discussion. Varapa Dhananjaya.
Appearing for the petitioner.
Ah,
My lords, I short date may be given, my lords.
it may be given.
Please, my lords.
Bere, matten what may be given?
My lords,
Bere, what may be given to you, except the date? But next time, Nino would come.
please, my lords, I'll do it.
You have to argue.
Please, my lords,
Huh?
please.
All right. But, ಯಾವ date ಬೇಕು?
My lords, next week, any date, my lords.
After vacation, weeks.
Please.
Entry
much obliged.
ಮಾಡಿದ್ದೇನು?
Please, my lords.
Absolute ಇದೆಯಾ?
Yes.
You only read, you have to come and argue.
Please, my lords.
Ajay Kadkod. 2 weeks. Entry to continue. ಯಾವ year? ಅದ್ರಾಗ entry ಮಾಡು.